And you'll
Thank
put,
you. You cut off, Sandy. What were you saying?
I was just going to ask if you were going to make me co-host so I could do that.
I thought you already are. Oh, what
Um,
happened? You were. Let's fix it. There we are.
What breakout room did you want me in?
You have one assigned to you that says Sandy's
Okay, I
meeting
just
and
have to
Sandy's waiting.
Scroll down. Thank you.
You're down at the bottom. I think you're
Yep.
like 15 and 16.
Thank you.
Thank you. Ms. Dudek,
Yes, ma'am.
good morning. I have you checked in for Mr. Levine's office. I have not seen an attorney from that law firm as of yet. What you will see here shortly is an invitation to go into his waiting room. As soon as one of the attorneys gets here, we'll get you relabeled and we'll get you connected with him. Good morning, Mr. Schmidt.
Good morning, Your Honor.
Who are you here for, sir?
Bell Creek Mobile.
You're here for Mr. Knight's office?
Yes, I am, Your Honor.
Thank you. What I will do is make you a co-host. If you see Mr. Porter, Mr. and Mrs. Porter, grab them, take them into a room and speak to them, and then come back out here. We're going to get going here at 9 o'clock. My policy is typically 15 minutes after the scheduled start time. I'll get to you as soon as I can. Since you have just one, I'll take you before I take people who have 10 and 15.
I appreciate that, Judge.
No worries. Thank you. Mr. Morton, you know the rules. You have a waiting room and a meeting room already available to you. I don't think that I have seen anyone for you, but let me finish getting people checked in and assigned where they are supposed to be.
Absolutely, Your Honor.
Mr. Horan, you've just been made a co-host to this meeting. There are people waiting for you in the Levine waiting room. Please go there, talk to them, come back out. We'll get the cases called. Thank you, sir.
Thank you.
Good morning, Ms. McLemore.
Good morning, Your Honor. How are you today?
I am super. How are you?
I am good.
Good morning, Mr. Novak.
Good morning, Judge.
How are you, sir?
I'm good. How are you doing today?
I am super. I have not seen Miss Miller yet. Give me a moment of finish getting people checked in. If we see her, please take her into your meeting room. It's labeled as Rabbits, but go there, talk to her. Let me know when you're ready.
I will,
Okay.
Judge. Thank you.
Thank you. There's a person on the phone whose number ends in 2940.
Yes, ma'am.
Your name?
Dorena Fields. I'm here for Martin and Dorena Fields.
You're here for a landlord tenant case?
Yes, ma'am.
Is there a reason why you're not on video?
I have a very old cell phone and I don't know how to work
Okay.
Zoom.
Okay, there's an attorney here already for that complex. What do you said you're
Okay.
here for Martin and Dorena?
Yes. Yes, we were adjourned 2 weeks ago because my husband was literally in the ER fighting for his life. He was in multi-organ failure.
Okay, let's get you moved into the attorney's space to talk to them about this case, okay? Ma'am with the blue shirt and the glasses, your name, please?
Sadiqa Robertson. Sadiqa Allen, I'm sorry.
You're fine. What time is your case scheduled?
9:15.
Ma'am, do you have your paperwork with you?
Yes,
In the upper right-hand corner is the case number 232028LT.
yes.
I received a dismissal from Mr. Cox's office yesterday of this matter. I have signed that dismissal. You're free to go.
Oh, okay. Okay.
Okay,
Thank you.
thank you.
All right, have a good day.
You too. Mr. Yocum, good morning, sir.
Good morning.
Ms. McLemore, did you need to speak to him?
I would like to speak to opposing counsel. I've spoken to Mr. Yocum, but I do need to speak with him, but I'd like to speak to opposing counsel first, if
I haven't
possible.
seen Mr. Cox. I haven't seen Mr. Cox's office as of yet. But sit tight when I see him. I think. Let's do this. If you see him, go in with him and chat with him. He has a waiting room You can
Okay.
stay in this main session until he gets here if you would like.
Okay, thank you.
Thank you. Ma'am with the dark hair and glasses,
Yes,
your name, please.
Danielle Porter.
Ms. Porter, I am going to get you relabeled. The attorney is here. His name is Mr. Schmidt. You'll see an invitation to go into the breakout room with him. Just give me a minute to get you relabeled.
Okay. Getting in the breakout.
Is Mr. Porter with you by chance?
Yes, he is.
Okay. You'll see that invitation here in just a moment. Ms. Fawning, did you speak to Mr. Berncrant?
Yes.
Okay. Just waiting for him to pop back out. Ms. Constantine?
Yes, hello.
Yes, ma'am. What are you here for?
Tedla versus Johnson.
Your Honor, if I may, Danette, this is Danette McLemore. I got a call from Sandy yesterday telling me that this was up today. I didn't speak, it was after 4 o'clock when I spoke to Sandy, so I was not able to speak to my client. I was not aware it was up until after Sandy called my office yesterday. So I'm a little lost today.
You, oh, okay. I realized
Your
who this
Honor?
case was. No. Listen, let's be clear. We don't do screaming out in this courtroom. We have 50 cases scheduled for this morning. I know there's a problem with this case, but let me get to the 9 o'clock cases. What we'll wind up doing in this case is scheduling a new date, but because I haven't called it, no one would even know where to look for it. And then I saw the attorney come in from Mr. Cox's office, Ms. Wilburn.
Good morning, Your Honor.
Good morning, ma'am. I'm making you a co-host in this matter. Ms. McLemore needs to speak to you about Mr. Yoakum. But before we, Ms. McLemore, if you would go in with Ms. Wilburn to discuss the case. And then Ms. Wilburn, you get going, meeting with your other tenants. I have a few 9 o'clock things to take care of. And then Ms. Constantine, I'll circle back to your case.
Thank you.
Judge, and quick question, if we have consents, do those need to go on the record?
Absolutely. Do not release people from your breakout rooms. I would like to speak to them to make sure that their rights have been read to them in their entirety.
Understood.
Thank you. Mr. Berncrant.
Yes, Your Honor.
This is 232002 LT. This is Gateway Townhomes versus Shanti Fawn. May I have your appearances, please?
John Berncrant for the plaintiff landlord, Gateway Townhomes.
State your name, ma'am.
Shantae Fawn.
Today is the day and time set for the second hearing in this matter. The parties have had an opportunity to speak. How are we proceeding this morning?
Yes, Your Honor. We have entered into a consent judgment or agreed to the terms of a consent judgment for possession only.
Those terms, sir?
Thank you. Our rent owing in the amount of $1,715, court costs of $167, the total redemption figure of $1,882, which must be paid on or before June 5. Otherwise, the tenant will need to vacate the apartment. And she has agreed to me signing a consent judgment with those terms, including the 3-day period in which to come back to court and ask that the judgment not be entered, and a 10-day right of appeal, which would be June 5th, actually, in this case.
Thank you. Ma'am, you were able to hear the attorney just now?
Yes.
And it's your agreement that a total of $1,882 is due and owing in this matter?
Yes.
And he explained to you that because you're not represented, you can come back to the court within the next 3 days and file a motion to set aside the terms of this agreement?
Yes.
And that you have 10 days to appeal this judgment?
Yes.
And because you appear by Zoom, there is not a signed consent judgment. Have you authorized him to sign your name to that consent judgment?
Yes.
Do you have any questions this morning?
No, ma'am.
His office will send a consent judgment with those terms just placed on the record. I'll sign it and the copy will be mailed to you at the address we have on record. Anything else, ma'am?
No. No, I'm sorry for
Ma'am, you're-
interrupting.
You're fine. You're free to go. You have a wonderful day, okay?
Thank you. You too.
Thank you. This is 232001 LT. This is Gateway Townhomes versus Strange. May I have your appearances, please?
Yes, John Berncrant for the plaintiff landlord, Gateway Townhomes.
State your name, ma'am.
Lasha Warner Strange.
Today is the day and time set for the second hearing in this matter. The parties have had an opportunity to speak. Mr. Berncrant, how are we proceeding in this matter this morning?
Well, Your Honor, we would seek the entry of a consent judgment. We have agreed to the terms of a consent judgment. The rent owing would be $821, court costs of $167, a total redemption figure of $988 to be paid on or before June 5, 2023. Otherwise, the tenant would need to surrender possession back to the management. She's also agreed for me to sign her name to such a consent judgment, which also contains 3 days in which to come back to court if she seeks to set aside the judgment, and a 10-day right of appeal period, which in this case would be 6/5/2023.
Ms. Strange, were you able to hear the attorney just now?
Yes.
And ma'am, it's your agreement that a total of $988 is due and owing in this matter?
Yes.
And you understand that because you're not represented by an attorney, you have 3 days to come back and ask the court to set aside the terms of this consent judgment?
Yes.
And because you appear on Zoom, there is not a signed consent judgment in the file. You've authorized the attorney to sign your name to that consent judgment?
Yes.
Do you have any questions this morning?
No.
His office will submit that signed consent judgment to the court. I'll sign it. Copy will be mailed to you at the address we have on record. You have a wonderful day. Thank you, ma'am.
You too. Thank you.
Thank you.
Your Honor, if I may, there was one other case that we're dismissing. The tenant showed up and she paid this morning, right before 9 o'clock, and I confirmed that. So I told her that I will dismiss the case in the courtroom.
Which is the
And I'll
case,
send
sir?
Yeah, 23-2003 LT, last name of Ashley Wazik. I'll send it.
Did you release her from, the breakout?
I told her that she should go back into the courtroom, but I don't think she's there.
It's fine. 232003 LT Gateway versus Ashley Wissick. The court, I did see her this morning and speak to her. Mr. Berncrant, I'll make a notation in the file that there is a dismissal forthcoming.
Okay, perfect. That should be my last matter.
Is it really? That was fast. Thank you, Mr. Berncrant. Good to see you. Have a good day.
Good to see you as well, Your Honor. Thank you so much. Bye-bye.
There is someone here that I'm sending you an invitation to go into the breakout room so that the court staff can relabel you. Please go there with her. This is 232127 LT. This is Romulus Tower versus Linda Miller.
Judge, good morning. Robert Novak appearing on behalf of the plaintiff.
Mr. Novak, this case was scheduled at 9 o'clock for a second hearing. It is now 9:19 by this court's clock. Linda Miller or anyone from 36500 Bibbin Street, number 404 in the city of Romulus. Mr. Novak, the defendant, having failed to appear, I'm looking in the breakout rooms. I
She
don't
likes
see
them
anybody by
saying
that
no.
last name. How would you like?
Judge, we would ask the court for a default judgment for possession. The back rent is $834, court cost of $164, redemptive amount $998, and I have June 5th as the writ date.
Thank you, Mr. Novak. Defendant having failed to appear, default judgment shall enter. Total due to plaintiff is $998 with a redemption date of 6/5. Have your office or have Mr. Rabbit's office submit that by email. Anything else this morning, Mr. Novak?
Other than to have a good holiday, Judge.
You too, thank you.
Bye-bye.
Mr. Schmidt, I'll be right back with you, but I need to go grab Ms. Constantine's file. Give me a second.
Thank you, Your Honor.
I'm sorry, Mr. Schmidt, you had the case with Porter?
Yes, Your Honor.
What happened to the defendant?
We went to a breakout room. I showed them the exhibits and closed the breakout room and came.
No,
here.
I'm sorry. I'm not asking it the right way. Were you ready for this case to be called?
Yes, Your Honor.
The defendants are not out here.
I apologize
So
if I
this-
screwed it up.
That's okay. We'll clear up what's here and ready. This is 231935 LT. This is McConnon, Tetla McConnon versus Shantu Johnson.
Noreen Constantine here on behalf of Mr. Tedla. Yeah,
Jeanette McLemore, present regarding Ms. Shantu Johnson, Your Honor.
Thank you. Just put on the court will put on the record from this perspective what happened, and then we'll figure out how to proceed. This case originally had its first hearing on 5/3. And then it looked like it was adjourned to 5/17. I called the case last week as the notice that is in the file indicates that the hearing date was 5/17/2023 at 9:30 a.m. I received a call from Sandy in the court civil department late yesterday afternoon, 3:45, 3:40 or so, with an indication that this case had been misscheduled, that it was actually supposed to be scheduled for today because Ms. Constantine was unavailable on the 17th, but not having that information on the 17th, when the case was called, the case was dismissed based on Ms. Constantine's failure to appear. Ms. Constantine called and spoke to Sandy yesterday, and the matter was placed on this morning's docket since Ms. McLemore was going to be present. That being the background and history of where we are, where we were, and the misscheduling being an error of the court, as the My Resolve report indicates that the case was supposed to be scheduled today and not last week. The dismissal that was entered in this matter on May 22nd is set aside on the court's own motion. How are we to proceed in this matter, Ms. Constantine?
well, since I'm not sure why the defendant isn't here. When Ms. McLemore was at the previous hearing with the magistrate, she heard me as well as he did that I was going to be out of the country, and he put it a week later to accommodate me. So this was the only date I knew about that we were supposed to have the hearing. And so I request that we set a date for Ms. Johnson to move out.
Absolutely
Honor.
not. You just heard me make the record that the court had an error. It was not a magistrate that did the original first hearing. It was my resolve. The report from my resolve said the date was to be today, but the court error was that it was scheduled for last week. Ms. McLemore was here with her client last week, and the notice to appear for the second hearing that the court staff mailed out indicated that the hearing was last week. I do not penalize tenants or any party when the court makes an error. That being the case, Mr. Hamilton, remove your cap. That being the case, I am happy to give a new date where both of you have your clients present and we can have a hearing in this matter if that's how you would like to proceed.
Yes. As soon as possible.
As soon as possible is something that you could coordinate with between yourselves. Is there a day that's better than any other day of the week for you, Ms. Constantine?
No.
I don't have landlord tenant again for 5 weeks, but I'd rather do it sooner than that. I'm gonna say June 6th. Is that a date you're available, Ms. Constantine?
Yes.
Ms. McLemore?
I am trying to look at my calendar right now. What day of the week is that, Your Honor?
It's a Tuesday. It's my general civil docket.
Okay, Tuesdays are generally good for me. Yeah, we do have dockets like at least 3 days a week, but Tuesdays should be good.
June the 6th, a Tuesday. I'm just pulling up the schedule to see.
I have instead dealing with this issue.
If it's not your case,
just
mute
need to be
yourself
called real
because you're
quick.
interrupting
That's why I did it,
proceedings.
you know, but I can still.
Okay, we'll talk about it after.
I'm looking at 11:30. Is
Oh,
that a good
no,
time for you? Oh,
Yes.
Yes, Your Honor.
6/6 at 11:30 by Zoom for a hearing on the complaint that was filed back on 4/17. Anything else, Ms. Constantine, in this matter?
No, I would like to speak with Miss McLemore in the waiting room if possible.
Then what you can, oops, sorry, I didn't mean to mute you, ma'am. What you can do is there is a.
We just did that one and then we put it in.
If you are not actively having your case heard, please mute yourself. You are disrupting these proceedings. There's a miscellaneous room. Ms. McLemore, if you want to go in the miscellaneous one with Ms. Constantine, I'll get you moved into that room.
Okay, that would be fine. I do have two
Thank you.
cases up this morning, Your Honor. Mr. Yoakum and I have another one, India Bryant. So, but no, I would be happy to speak to Ms. Constantine.
Thank you. Ms. Constantine, please go there. She'll be there shortly. This is 232063 LT. This is Bell Mobile Village versus Porter and Porter. Your appearances, please.
Good morning, Your Honor. Oliver Schmidt appearing for Bruce Knight, my boss, for Bell Mobile Village.
Ma'am, turn your video on and have you both state your names for the record, please.
William Porter.
Danielle Porter.
Thank you. Today is the day and time set for the second hearing. The parties have had an opportunity to speak. Mr. Schmidt, how are we proceeding this morning?
The hearing, Your Honor.
With the hearing?
Yes, Your Honor.
Okay. We have 35 other cases, so we will circle back to the hearing. It'll be closer to, I would say, 11 o'clock. Do you have your witness here for Bell Creek?
I will, Your Honor.
Mr. and Ms. Porter, do you have all necessary documents and witnesses?
I got documented video footage. I don't know how I did
Not
that.
with the hat on the record, sir. Absolutely not.
I got documented
Question-
footage of,
No, my question is, do you have all necessary documents and witnesses? Yes or no?
I got documented footage on camera.
Thank you. What we'll do is the court has other cases. I'll go through all of these other cases and your will be the first contested hearing we have this morning. So sit tight. You may mute yourself, turn your video off, go about your morning until I call your case again, okay?
Thank you, Your Honor.
Okay.
Thank you, Mr. Pallets. I'm sorry, Mr. Morton.
Close enough, Your Honor. Hello.
What do you have ready, sir?
Your Honor, was it Miss Fields? Dorina Fields is present. We have a resolution in place. Was it
231321 LT. Sorry for cutting you off. Harbor Club versus Fields and Fields. Appearances, please.
for the record, Your Honor, Attorney Ian Morton of Pallets Law on behalf of the plaintiff.
Dorina Fields here for Dorina and Martin.
The resolution, Mr. Morton.
Yes, Your Honor. Parties have spoken. They've agreed to enter into proposed conditional dismissal. The terms are as follows. Rents retained are $3,950.13. Court costs of $189 for a total of $4,139.13. Was it the payment date on that, which will also include June's rent on top of that, is June 14th, 2023. This will be entered as a conditional dismissal. Mr. Martin Fields recently had a was an emergency, which has affected some matters. So we've also agreed to enter into a term that will say no order of eviction will be entered without hearing as well. I did advise Ms. Fields specifically in regards to her rights in regards to the fact that the agreement is not final for 3 business days, the appeal period, as well as the fact that she did give me permission to sign her name. She did say that Mr. Fields is present and can confirm that he's in agreement, but he can't really have long conversations at this moment.
Thank you. Ms. Fields, were you able to hear Mr. Morton just now?
Yes, ma'am.
And it's your agreement that a total of $4,139.13 is due and owing in this matter?
Yes, ma'am.
And you've agreed to entry of a conditional dismissal with these terms?
Yes, ma'am.
And that you will pay this amount or vacate the property by June the 14th, 2023?
Yes, ma'am.
And that there will be no eviction without hearing in this matter?
Yes, ma'am. I understood.
And because you appear by Zoom, there is not a signed conditional dismissal. Have you authorized Mr. Morton to sign your name to a conditional dismissal?
Yes, I did.
Mr. Morton's office will prepare that document submitted to the court by email. The court will sign it and the copy will be mailed to you at the address we have on file. Do you have any questions this morning, Ms. Fields?
No, I don't. No, I don't. Thank you.
Thank you for your patience. Have a good day.
And Your Honor, just for clarification, we're going to have Mr. Martin Fields entered into this agreement by default because he's can't formally go on the record right now, but all the same terms apply.
Okay.
Thank you, Mr. Morton, for that
Thank you.
clarification. This is 231913 LT. This is Nasser Holdings versus Macco Tire and Robert Hamilton. May I have your appearances, please?
Yes, this is Robert Hamilton.
Dennis Harris, P 35791, appearing on behalf of the plaintiff.
Mr. Harris, have you had an opportunity to speak to Mr. Hamilton?
Yes, I have, Judge. Mr. Hamilton pretty much acknowledges the debt, but still wants more time to vacate the premises. He hasn't paid rent since January. I'm asking the court to enter a judgment. I'll just run through the numbers.
No, sir, you will not. No. If you don't have an agreement with him, this is contested.
Okay.
Right?
That's
And we'll
correct.
let's do the easy cases first, okay?
All right. Okay,
Okay,
thank you.
sit tight. I'll get back to you in just a moment.
All right, thank you, Judge.
Mr. Morton, did you have something else ready?
No, Your Honor, the only other matter was that I was just looking through to see if there's anybody else available. I only have one other matter scheduled at 9 o'clock and that person has not appeared yet, so it'll be a default. So when you get to that point, we'll do the default.
Thank you very much. Was it the Henderson matter?
I'm on that one, Your Honor.
Right.
Hmm.
Did you
Yeah,
speak? Were they here?
I entered into a consent with Mr. Henderson default for Starlisa Henderson, but it looks like he just logged off. He was the one that was making noise on the record earlier. I don't know if he was booted or.
No, he wasn't. I don't boot people.
Yeah.
I just mute them. I don't like taking. I don't know why people don't stay. This is 231-936 LT. This is the Parks of Belleville versus Gregory Henderson and Starlisa Henderson. Your appearance, please, sir.
Good morning, Your Honor. Ryan Wojcik, P84535 on behalf of the plaintiff.
Uh-oh, leave.
Today was the day and time set for the second hearing. I know that the tenants had checked in. Your indication was that you spoke in the breakout and they left, or he left.
Your Honor, I did have a chance to speak only with defendant one, Gregory Henderson. We were able to enter into a consent judgment of possession only. Mr. Henderson stated that he was a probation officer. He was initially logged into a different room and he had to go to work. So he was, so I don't know if he logged off in the time between us speaking at around 9:20 and now. I would ask that the court enter the judgment today either by default or by consent.
The judgment will be entered by default as to both tenants in this matter. The case was scheduled at 9 o'clock. It's just 9:35 right now. If you can't wait long enough for a case to be called, it'll be entered by default. The past due rent in this matter is how much, sir?
Your Honor, we're showing past due rent of $903.77, cost of $198 for a total redemptive amount of $1,101.77. The writ date we are requesting is June 5th, 2023, as well as the appeal date. Partial payment would not prevent eviction. No money judgment is entered.
If you would be kind enough to have your office submit that default judgment to the court by email, I'll sign it and copies will be mailed out default as to both tenants in this matter. Anything else this morning?
No, Your Honor, I will submit that in just 5 minutes. Thank you very much.
Thank you. Have a good day.
Thank you, you too.
Thank you, Judge.
Good morning, Professor Edmonds.
Morning, Judge. How are you?
I'm super. How are you?
Good. I'm here on 232049 Park Estates v. Stephen Neely. We submitted a stipulated dismissal yesterday, but I just want to make sure that had been received.
That's why I was shaking my head. I received it this morning and I signed it. And
Great.
I wanted to let you know so you can get on with your day. Thank you so much.
Perfect.
for
Thank you.
checking on
Good
that.
day.
Take care.
Bye.
Miss Macklemore.
Yes, Your Honor.
Mr. Yocum, did you speak? Oh, have you spoken to Mr. Cox's office this morning on this matter?
I have not. I was looking for the representative
Oh.
from his office.
She is here.
Can you tell me who that is?
It's Jen Wilburn. She's in the Cox meeting room.
Okay, so I can go in there. Is she with
Absolutely,
anybody?
thank you.
May I ask you, Your Honor, there was a case that was handling, that Ms. Cooper was handling, Newsome. Was that a dismissal? It should have been a dismissal with the CD.
Miss Cooper and Newsome?
Yes, I don't know the case number.
If you don't know the case number.
I'm sorry. I can.
No, I don't. Hold on one second. I don't remember seeing Miss Cooper's name on anything.
Okay.
Nope, I don't remember seeing her scheduled this morning.
Okay, great. Thank you.
You're welcome. Ms. Jones, did you speak to Mr. Cox's office?
Yes.
Okay. Just waiting for them to pop back out. Mr. Schmidt and Mr. and Mrs. Porter.
Yes, Your Honor.
This is a recall of 232063 LT. This is Bell Mobile Village versus Porter and Porter. Mr. Schmidt, do you have a representative here from Bell Mobile?
I was just emailing with the park manager and advised her to sign on at 10:30 for the 11 o'clock suspected time that the court advised. But I can
Thank you.
expedite that.
No, I was, if we could get to it in this small break, I was gonna try to get to it.
I would love to, Your
But-
Honor.
I understand. This is a recall of 231913 LT Nasser versus Madco and Hamilton.
Yes,
Ready,
Your
Your
Honor.
Honor.
I
Dennis
have-
Harris.
I have your appearances. And we were going to treat this as a contested matter, but we have a little break right now. Mr. Harris, you were starting to say that Mr. Hamilton had not paid rent since January and wanted more time. The rent to retain possession is how much, sir?
It's 4 months at $6,500 a month, so it's $26,000. There's late fees of $585. There's a legal fee of $1,500. I can put proofs into the court if the court desires. Filing fee of $130 and $68 service fee, for a total of $28,283 to retain possession. In addition, Judge, I'd be moving for a money judgment against both the tenant and the guarantor. Mr. Hamilton guaranteed the lease, but I would stipulate, obviously, we're only entitled to $25,000. So I'd move for the entry of a money judgment for $25,000 and agree to waive anything over the $25,000 that may be due.
Mr. Hamilton, were you able to hear Mr. Harris just now?
I did.
And sir, do you agree to the amounts that he just placed on the record as true and accurate?
As long as it's not over 25, correct. I think January was paid. It was the other months that weren't.
I'm sorry?
I think he said that January wasn't paid. I believe January was paid and the other months that were not paid. I believe.
So wait. So Mr. Harris, what he put on the record totaled $28,283, but the jurisdictional limit in this court is $25,000. So are you agreeing that that is at least the amount that's due and owing $25,000?
Yes, ma'am.
Okay. And so, Mr. Hamilton, what happens is if you agree that the amount due and owing is accurate as advised by the attorney, there's not a triable issue. And if the only issue is payment, Mr. Harris and Mr. Hamilton, have you talked about a payment schedule? Mr. Porter, take your hat off. Have you talked about a payment schedule, Mr. Harris?
Your Honor, the tenant hasn't made any offer to pay. They want to vacate, but he just wanted more than the 10 days. And it's been 3 months we've been waiting for him to vacate. So I can't give him any more than what the court allows, which is 10 days.
Your Honor, my dilemma is that we've been there a little bit over 25 years. A lot of things have changed where we are, which has made it impossible for us to continue at that location. We're not disputing what the attorney is saying. My only dilemma is I have a lot of customers there that have vehicles that parts were ordered for because of, they say COVID, none of the parts that came in. We have been trying to get the parts in as soon as possible. It's not us that's holding it up. I asked him to give us 30 days and we would be out of there. That was what I was requesting.
Mr. Hamilton, the issue from the court's perspective is that this is not a termination case. This is a non-payment of rent case. It's a pay and you stay. And although statute provides 10 days, there may be extraordinary circumstances where more time is advisable based on how long you've been at that property and the fact that it is in fact commercial space. The court would find that there was more time necessary, but it's just not you vacating and having your customers remove their property. It's paying for the time that you are there, whether it is January, February, March, April, or just these last 3 months or something. So the court is inclined to enter Mr. Harris's judgment, capping the damages at 25,000 plus the court costs. But then the question is, if you want more than the 10 days, the court would want to hear a plan going forward.
I pay for the remaining or another 30 days. I'll pay for 30 days. Can you hear me, Your Honor?
I hear you, sir, but I can't force them to ignore the fact that there is 5 months of rent due and owing. So
How can I proceed? I'm not understanding what you're asking me then if I'm willing to pay for the next 30 days.
I'm saying if you haven't paid since either by Mr. Harris's testimony since December or your testimony since January.
Judge, let me make sure the record's clear so we have the numbers. He paid through January, so he paid through January 30th. He owes for February, March, April, and May. So he owes 4 months, February, March, April, and May at $6,500 a month. And I think everybody agrees to those numbers.
Okay, then Mr. Hamilton, what I was saying was, if you acknowledge that you owe these 4 months of rent, and I understand COVID and parts and everything else, but it's 10 days to pay or vacate. To go beyond that, I'm sure Mr. Harris's client would like to hear some different plan, but it doesn't sound like there is one.
I can have a check for the next 30 days on Monday. And the only thing, I mean, because I hate for something to happen to the customer. I mean, they know the vehicles that are in the lot that they see and they're not mine. They're customers whose parts aren't there. And we're just waiting on them to come in so we can install them. I'm asking that if I get them, I'm sorry.
Mr. Harris, would your client be willing to allow 30 days if this 6,500 is paid by Monday? It's the holiday, it would actually be May 30th.
It'd be Tuesday then.
So he'll pay $6,500 by Tuesday.
And that'll give me 30 days from today.
We do the 15th we do June 15th. So basically you'd be out on the 15th, and let me see what day of the week that is.
The 15th is a Thursday.
My problem is, Attorney Harris, it's not really with me vacating the property. It's with me having the parts to put on the customers' vehicles that are there. I don't want to get their vehicles towed and have it
Mr.
put
Harris,
in impound.
can the two of you go back in the breakout room and hash this out, or do you want me to enter a judgment and you work out the terms off record? Like leave and talk to Mr. Hamilton outside
Judge,
of this hearing.
If you're willing to just enter the judgment as we've discussed, then basically he called me while this hearing was going on. Mr. Hamilton, I'll call you back and I'll see if for the payment of some money, we can extend you a little more time.
Okay, thank you.
So for Mr. Harris, is it my understanding that we are taking up, I'm sorry, the judgment will be for 25,000 plus your court costs?
That's correct.
With Mr. Hamilton to pay 6,500 by May 30th. And the balance be a pay or move of June the 15th. Is that what you're saying?
That if that's agreeable to him, I'm good with that.
I'm not sure of today's date, but it'll be 30 days from today's date. That's what
You
I'm
want
trying to
Today
agree
is
So
the
to.
you
20
want-
today is the 24th. That's 1, 2, 3, 4. That would be actually June 23rd.
That's because it's only when the parts are going to arrive to me so we can have them on the customer's vehicles.
And that's fine. So it'll be pay or get out by June 23rd. But if
No,
he
And
does,
Mr. Harris, if you submit it after hearing, okay.
but no, we can agree to that today, Your Honor. We'll agree to that right now. I'll go ahead and prepare the judgment. So 6,500 has to be paid by May 30th. If it's not, then he's out in 10 days. If he pays 6,500, then he has to be out by June 23rd. Obviously, unless he brings the rent current.
Correct.
That's your understanding, Mr. Hamilton?
Correct. And the rent being current, are you saying that's just 25,000?
That would be the 28,283.
Now, if you all need to work out something else, you'll have to do it outside this record. There are people popping back in. I have the basic framework of the agreement. I'll wait for
Thank you, Your Honor.
receipt of the email. If Mr. Harris, if your office will send the email of the agreement to the civil department, I'll sign it and get it back to the parties.
Okay, thank you, Judge.
Thank you. Have a good day, Mr. Hamilton.
Thank you, ma'am.
Mr. Porter? Would you walk into courtroom number 1 smoking? It might not feel like it to you, but this is actually court. And I would ask that you respect it as such. Mr. Morton. This is 231939 LT. This is Van Buren Estates versus Tony Walker.
For the record, Your Honor, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Thank you. Tony Walker or anyone at 45 Maple Drive. Mr. Morton, I am looking in the court's virtual breakouts. I don't see anyone by that name. There's no one responding to the court call. The case having been scheduled at 9 o'clock, it now being 9:52, defendant having failed to appear. How would you like to proceed?
Your Honor, at this time, we'd ask a default judgment for possession be entered. I will advise the court that there is a nominal balance due at this time based on a recent payment of $1,000 that's been submitted. At this time, the only balance due and owing is $116.38. My client did have communication with Mr. Walker, was it last Friday, in which he said he would bring it current. That was not completed. But at this time, we would ask that a judgment be entered for that remaining balance due. We'd understand if the court would like to put a condition on it, i.e. no writ without hearing or something similar.
The $116.38 is inclusive of court costs.
That is correct, Your Honor.
The court will enter that default judgment with the provision no writ without hearing. Have your office submitted. Thank you, Mr. Morton.
Thank you very much, Your Honor.
This is that it for you, Mr.?
Your Honor, I
Is
have,
that it until 10 o'clock?
correct, 10 o'clock and 11 o'clock are my next hearings.
Okay, I'll see you. Well,
I'll be here all day.
thank you, sir.
Yes.
This is 2317350 OT Huron Estates versus Ralph DeHate. May I have your appearances, please?
Yes, I'm here. Hello.
Mr. DeHate, I'm trying to get the attorney out here. Give me 1 second. Mr.
Okay.
Horn, I've just called the DeHate matter. My 9 o'clock cases are not moving. So have you spoken to Mr. DeHate?
We have, Your Honor, and we would request a 30-day adjournment to allow him to get his property back up to the community standards that's within agreement with our property manager and Mr. DeHate.
Mr. DeHate,
Yes, ma'am.
were you able to hear Mr. Horn just now?
Yes, ma'am.
He's asking that this matter be adjourned 30 days.
Yes, ma'am.
Is that your agreement and understanding?
Yes, ma'am.
My next landlord tenant date is not till June the 28th. Mr. Horn, is that acceptable?
That's acceptable, Your Honor.
The civil department will mail out a notice that this case is adjourned to 6/28 at 10 a.m. for Mr. DeHate to bring the property up to community standards. If these issues resolve themselves before that date, Mr. Horn's office will submit a dismissal of the matter. Anything else this morning, Mr. DeHate?
No, ma'am.
Have a good day, sir.
You too. Thank you.
Thank you. This is 231737 LT. This is Huron Estates versus Angela Dudak and Art Stillfried. May I have your appearances, please?
Danny Horn, P 1774 for plaintiff.
Hi, Angela Dudek.
Ms. Dudak, where is Mr. Stillfried?
He's in the house sleeping. He had a rough
He's
night
sleeping?
last night. He had a rough
He's
night last night. He was up all night not feeling well. He was going back and
Mr.
forth to the bath. He was going back and
Ma'am?
forth to the bathroom with the runs.
Ma'am,
Yes,
have you had the opportunity to speak to Mr. Horn?
yes.
Mr. Horn, how are we proceeding this morning?
Your Honor, like the previous matter, we would ask for the 6/28 at 10 a.m. date as an adjourned date. Ms. Dudek has represented that they plan to bring their property up into the community standards as well. They'll work with the property manager, Bob Cost, in the meantime.
Ms. Dudek, is that your understanding and agreement?
Yes, ma'am.
This matter will be adjourned to 6/28 at 10 a.m. The next time that you appear in this court, you and defendant number 2 should appear at the same time and be video ready. Notice will be mailed to you of that 6/28 adjourn date. Have a good day.
Thank you.
Thank you, Your Honor.
This is 231738 LT. This is Huron Estates versus Wendy Augustinas and John Garcia.
Danny Horn, P 1774 for plaintiff.
Mr. Horn, I am looking in the court's breakout rooms. I don't see anyone by the last name of Augustinas or Garcia. Is there anyone here from 22021 Latour, number 52 in the city of Romulus? This case having been scheduled at 9 o'clock, it now being 9:57 by the court's clock, defendants having failed to appear. How would you like to proceed?
We request a possession default judgment. This is a termination of tenancy, so the normal 10-day writ period will apply, and I can draft and submit that default judgment, Your Honor.
Thank you. Defendants having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with 10 days to vacate the property. Have your office submit that for entry, please.
Thank you.
Thank you. Thank you. You can go back into your meeting rooms. We're going to do a hearing in the Porter matter. This is 232063 LT. This is the third time this case has been called. Mr. Schmidt, I saw your witness come on. Are you ready to proceed in this matter?
We are, Your Honor.
Mr. and Mrs. Porter, are you ready to proceed?
Yes.
Yes.
And the witness from Bell Creek Village, your name, please, ma'am.
Lisa Beatty.
I'm sorry?
Lisa Beatty.
And how do you spell your last name, ma'am?
Beaty.
Thank you. Ms. Beatty, Ms. Porter, and Mr. Porter, raise your right hands. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes, ma'am.
Thank you. Mr. Schmidt, any opening statement?
Yes, Your Honor. This is a just cause termination that my client's moving for. There is, as the record will reflect, and the testimony will reflect, there is late rent with late charges in excess of $1,333, plus filing and court fees, service fees, and just cause termination under most of the statutory requirements from 600.55 or 5775 and extensive physical damage, threats, failure to maintain appearance, failure to make timely payment on 3 or more occasions, conduct constituting substantial annoyance, quiet enjoyment, and health and safety of the employees and tenants. For those reasons, if a court permit, I'd like to call my first witness, Lisa Beatty, please.
Before you do that, Ms. Porter, do you wish to make an opening statement in this matter? Not testimony, but just your statement.
Yes.
Opening statement, please.
My opening statement is that half of what they're telling you is incorrect and lies, and that they're just making up stuff. And I got proof on my cameras.
How do you propose to show that camera video?
I don't know. I mean, I could send it to you guys. I didn't know how we would do that. I can email it to you. I got 3 video footages.
Mr. Schmidt, hearing that there is video testimony, I don't know how we could possibly proceed with trial this morning.
Your Honor, I very much oppose the delay of today's trial. I'm available, and
I don't.
My tenant or my client seeks not only immediate eviction for cause for the reasons that will be stated on the record through testimony and police report submitted as evidence, but also no contact order, which I've advised my client it has to be taken up with another court.
I'm sorry, Mr. Schmidt, you have documents to present this morning. How do you intend to present it and allow the Porters time to review it?
Screen sharing, and I've showed them in the breakout room.
You didn't show us nothing in the breakout room, and Your Honor.
That's absolutely incorrect, Your Honor. Absolutely wrong.
Excuse me, Your Honor. No, he didn't. He didn't show us anything. He showed us a computer screen and we couldn't see anything. And Your Honor, also, I do want time because, like I said, I have 3 video footages that goes against everything they're saying. And since our last court hearing with you, they came on my property and stole everything that I own. Yeah. And I got video footage of their company coming up and taking all of my stuff. They stole my 4-wheeler, my riding lawnmower, my weed whacker, and everything by my house. I got video footage of it.
When I raise my hand, it's usually because people are talking, they don't need to talk.
Oh, okay, sorry.
No, you're not. In order to be fair, parties should have an opportunity to review the documents and propose evidence in the matter. The court believing this to be a simple matter, I thought we would take it up as a contested matter this morning. I don't believe that there's adequate time to do that, given the fact that there are 19 other people waiting to be heard, participating in these proceedings. Mr. Schmidt, I will make myself available for you, your witness, Mr. and Mrs. Porter, and all of your necessary documents to come into court. You tell me how soon you'll be ready.
1 o'clock, Your Honor.
I won't be ready today, Your Honor. I have a job today. That's scheduled this afternoon.
What's tomorrow look like?
I can do it Monday.
Nope. Mr. Schmidt,
Yes,
what's your tomorrow schedule look like, sir?
I'll be there when the court, anytime.
Ma'am, I have a job that is scheduled today. I can prove it to you through work. I'm a heating and cooling guy. I'm installing a furnace and AC in Romulus, and I will not be available starting this afternoon.
Mr. Porter, when are you next available?
It can be after tomorrow. It can be anytime after tomorrow, but I'll be busy from tonight until after tomorrow.
Friday, the 26th.
That'll work.
Your
I'm
Honor,
asking Mr. Schmidt too, if it doesn't work.
For the record, I'm going to request substantial court cost for the delay and for the, personal appearance.
No problem, because I'm going to sue them for everything they stole from me.
I'm available.
Friday at what time? Friday at what time, Mr. Schmidt?
10 a.m., Your Honor.
10 a.m.?
If the court-
Mr. and Ms. Porter, are you available Friday at 10 a.m.?
Yes, I am, ma'am.
Are we talking about an in-person or Zoom, Mr. Schmidt?
As much as I'd like to do by Zoom, I suspect in person will be more efficient for the court's time, Your Honor.
I think so
Thank
too.
you. We will put this matter over till May the 26th at 10 a.m. It will be live here in courtroom. Hold on one second. My secretary, my court recorder is not here. I need to make sure we have coverage. But because this hearing is in 2 days, there will be time to mail notice to appear. Mr. Porter, I'm going to have you go into the breakout room with Sandy, provide an email address so she can email you notice of the hearing. Mr. Schmidt and Ms. Beatty, I will see you here on Friday morning at 10 a.m. in courtroom number 1. Anything else this morning, Mr. Schmidt?
Your Honor, may the plaintiff provide to the court proposed exhibits that the court will then transmit via email, perhaps to the tenant?
No, you can serve Mr. Porter, Mr. and Mrs. Porter by email, as well as email the court, CC the civil department when you email Mr. Porter, Ms. Porter. Do you have their email address?
I do not, Your Honor.
Would you go back into the breakout room with Mr. Schmidt, provide your email address, and then we'll have you, hold on.
I hate to ask the judge here, Your Honor, but what is the court's civil email address?
I'm going to get you all off of my screen here momentarily. I'm getting the civil department supervisor back out here so we can get.
Yeah, I'll need it too.
No. Sandy?
Yes, Judge.
This is 232063 LT.
Okay.
If you would go into your meeting room with Mr. Schmidt and Mr. Porter, this case is being adjourned to Friday morning at 10 a.m. live in person. They have exhibits they want to send. If you would get email addresses, good email addresses for both sides, email their notice to them. Mr. Schmidt and Mr. Porter and Ms. Porter will both be emailing their exhibits for Friday morning's hearing. I just don't want it all on the record, but if you would take them into the breakout room, get the contact information, their email,
Okay.
I'd appreciate it. Thank
Okay.
you.
You're welcome.
It just went off the rails. Ugh. Mr. Cox's office, Ms. Wilburn, this is 231944 LT. This is Swan Creek versus Jordan.
Good morning, Your Honor. Jen Wilburn, P83143 for the plaintiff. Was this Latisse Jordan?
Yes.
Your Honor, we will be submitting a dismissal. The resident has paid in full. I will get that into the court this morning.
Thank you, ma'am. This is 231945 LT. This is Swan Creek versus John Williams.
Jen Wilburn, P83143 for the plaintiff.
John Williams. Unmute yourself, state your name for the record, sir.
My name is John Williams. I apologize, Your Honor. I had
Don't
two
apologize.
screens.
Thank you, Mr. Williams. You're good. Today is the day and time set for the second hearing in this matter. Have the parties had an opportunity to speak?
We have, Your Honor. We are unable to come to a resolution at this time. I think we're going to need to have this set for a trial. Though, Mr. Williams, before you leave today, I will ask to go back into a breakout room to get your contact information.
Ms. Wilburn, what's the rent owing in this matter?
Your Honor, right now I'm showing outstanding rent in the amount of $3,190.93. Court costs of $164 for a total of $3,354.93.
$3,354.93.
That's correct, Your Honor.
And Mr. Williams, are you disputing this amount?
Your Honor, I've had problems and issues with Swan Creek, and that was the reason why we were not able to come to an agreement today. I made a payment when they first filed their motion, a partial payment back on April 29th, which
Williams?
they accepted.
Mr. Williams,
Yes,
Ms. Wilburn started by saying that you don't have an agreement. My question to you is, were you disputing this amount? And your answer is yes.
yes.
Okay. And are the parties, well, Ms. Wilburn indicated we needed a trial date. How long will it take you to exchange documents?
Judge, I should just have a lease and a ledger, potentially a couple work orders, so I could have those mailed out tomorrow. Or I can go and get his email and have them emailed to him today.
Mr. Williams, your documentation for trial?
Your Honor, I have some photographs and some video of the property of things that weren't done and completed. That's what we have been going around. I have not disputed my monthly amount. I asked for a rent credit for the things and the time that it took to get things completed, because I didn't have the property that was actually offered to me. We have discussed making the payment in full if we do come to a resolution that I have agreed to. But like I said, I just want us to figure out what this rent credit, if it will happen, would be, so that we can clarify what I will be paying.
June 6th at 1 p.m. It's a question.
That works
Ms.
for me, Your Honor.
Wilburn. Mr. Williams,
I am looking right now. I am working for the school district. I just need to make sure that I have nothing on that day. June 6th is fine.
at 1 p.m. on Zoom.
1 p.m.
What I will have you do, Ms. Wilburn indicated the need to get your contact information. You'll go back into the breakout room. Anything that you want the court to consider on that day at that time needs to be submitted to the civil department as well. They'll forward it to Chambers.
Ms. Wilbur has all my contact information, Your Honor.
I do not, Mr. Williams. I will need to go into a breakout room and get that.
Oh, okay. 'Cause Swan Creek has my email and everything, but
Mr. Williams.
no problem.
Mr.
I can be
Williams.
there.
Go back, please. Ms. Wilburn has a few other matters I'm going to call, and then she'll join you there to get that contact information, okay?
Yes, Your Honor.
Thank you. This is 232027 LT. This is Bellvilla versus Yocum. May I have your appearances, please?
John Wilburn, P 83143 for the plaintiff.
Good morning, Your Honor. Danette McLemore appearing on behalf of Ryan Yocum.
This is Ryan Yocum.
Thank you. Today is the day and time set for the second hearing in this matter. The parties have had an opportunity to speak, Ms. McLemore.
Yes, we have. And I believe
How are we
reached
proceeding?
we have reached a resolution in this matter. Ms. Wilburn, if you could perhaps give the court the exact numbers.
Sure. Your Honor, there's outstanding rent of $2,282.42, court costs of $164 for a total of $2,446.42. Half of that, which comes out to $1,223.21, is going to be paid on or before June 5th. The remaining half of $1,223.21 plus June rent and costs are going to be paid on or before June 30th. We are going to be waiving the 56-day rule in this matter. And if he defaults on the 6/5 payment, my client would be able to request an order of eviction at that point.
That's correct.
How long will it take you to get this resolution drafted and signed and submitted?
Should be able to get it before noon today.
Thank you much. Get that executed, email over to the civil department. They'll get it upstairs for signature. Anything else, Ms. McLemore?
No, that's it, Your Honor. Thank you.
Anything else in this matter, Ms. Wilburn?
No, thank you, Judge.
Thank you. Thank you, Ms. McLemore, Mr. Yocum, for your patience. Have a good day.
Thank you.
Thank you.
This is 231946 LT. This is Swan Creek versus Amy Schroeder.
And Jen
Amy
Wilburn,
Schroeder, I'm sorry.
Jen Wilburn for the plaintiff.
Amy Schroeder or anyone at 38922 Bayview, number 58, New Boston. This matter was scheduled at 9:15. It is now 10:15 by the court's clock. Defendant having failed to appear, ma'am, how do you wish to proceed?
Your Honor, I would be requesting a default possession only judgment. Outstanding rent is $1,288.08. Court costs $164 for a total of $1,452.08 to be paid on or before June 5th or a writ could issue.
Defendant having failed to appear as requested by this court, default judgment shall enter with a total due to plaintiff of $1,452.08. Plaintiff's office will submit that judgment for entry. This is 231948 LT. Strike that. This is 232024 LT. This is Bellvilla versus Shondelyn Jones. May I have your appearances, please?
Jen Wilburn, P 83143 for the plaintiff.
Ms. Jones,
Yes.
state your name, ma'am.
Shondelyn Jones.
Thank you. Today is the day and time set for the second hearing in this matter. The parties have had an opportunity to speak. Ms. Wilburn, how are we proceeding?
Your Honor, we have a consent judgment for you. Outstanding rent is $685.95. Court costs of $164 for a total of $849.95 to be paid on or before June 5th. I did go over Ms. Jones's rights under MCR 4.201I and requested her permission to sign this to submit to the court.
Thank you. Ms. Jones, were you able to hear Ms. Wilburn just now?
Yes.
And it's your agreement that a consent judgment will enter showing that a total is due and owing to the plaintiff of $849.95.
Yes.
That you will pay this amount or vacate the property by June the 5th.
Correct.
And Ms. Wilburn explained to you that because you're unrepresented, this judgment may be set aside if you file a motion with the court within 3 days and that you have 10 days to appeal this judgment.
Yes.
And because you appear by Zoom, there's not a signed consent judgment in the file. You've authorized Ms. Wilburn to sign your name to a judgment.
Yes.
Do you have any questions, Ms. Jones?
No.
Ms. Wilburn's office will submit that judgment for entry to the court. I'll sign that copy will be mailed to you at the address we have on file. Thank you for your patience this morning, ma'am. Have a good day.
You too. Bye-bye.
Thank you. This is 231948 LT. This is Swan Creek versus Michael Galvin. Michael Galvin or anyone at 39080 Carlisle, number 171 in New Boston. Ms. Wilburn, the court notes your appearance for the record. There's no one responding to the court call. There's no one by that name in the court's breakout sessions. Defendant having failed to appear, ma'am, how would you like to proceed?
Your Honor, I would be requesting a default judgment today. There is outstanding rent in the amount of, let's see, $470.06. Court costs $164 for a total of $634.06 to be paid on or before June 5th or a writ could issue.
Defendant having failed to appear, default judgment shall enter with a total due to the plaintiff of $634.06. Plaintiff's office to submit that judgment for entry. This is 231949 LT. This is Swan Creek versus Alexander Guess or anyone at 23720 Somerset, number 162.
And Your Honor, we should have submitted a dismissal on that. I will double check that it was in fact submitted to the court.
Thank you, ma'am. This is 231952 LT Swan Creek versus Bonnie Boyer and Alexandria Welch.
Jen Wilburn for the plaintiff.
Is there anyone here for Boyer or Welch? Anyone from 23720 Somerset, number 162 in New Boston? This case was scheduled at 9:15, is now 10:20 by the court's clock. Neither defendant have responded to the court call. Ms. Wilburn, how would you like to proceed?
I would be requesting a default possession only judgment. Outstanding rent is $3,149.88. Court costs of $198 for a total of $3,347.88 to be paid on or before June 5th, or a writ could issue.
Defendants having failed to appear, default judgment shall enter in favor of plaintiff and against defendants with a total due of $3,347.88. Plaintiff's office to submit that judgment for entry. This is 231954 LT. This is Swan Creek versus Patty Talicia or Linda Baum. Or anyone at 39112 Bayview, number 64 in New Boston. Ms. Wilburn, the court notes your appearance for the record. I don't see anyone with those last names or those names in the court's breakout sessions. Defendants having failed to appear in this matter, how would you like to proceed?
I would be requesting a default possession only judgment. Outstanding rent is $721.12. Court costs of $198 for a total of $919.12 to be paid on or before June 5th, or a writ could issue.
Case having been scheduled at 9:15, it now being 9:21, default judgment shall enter in favor of plaintiff and against defendants with a total due of $919.12. Plaintiff's office to submit that judgment for entry. This is 231958 LT. This is West Village Estates versus Sherry Bergeron. Sherry Bergeron or anyone at 38702 Cherokee Drive, number 198 in Romulus. Ms. Wilburn, the court notes your appearance for the record. I'm sorry. No. Not Ms. Wilburn. Nope. That is not that right match. Mr. Levine's office.
Yeah, Judge, I believe that
Horan.
concluded my matter.
It's Mr. Horan. Thank you so very much, Ms. Wilburn. Have a good day.
Thank you, Judge. You as well.
Ms. Pearson,
Yes.
have you spoken to the attorney for West Village this morning?
No.
Ma'am, you'll see an invitation to go into a breakout room with him.
Okay.
Have you, let me see. Hold on one second. Oh, they still have you. Okay, let's fix this. Mr. George, what were you here for, sir?
Good morning, Your Honor. I'm here on Anmark versus Rogers.
I'm here in that
Thank
matter
you.
as well,
Here's
Your Honor.
Have you all spoken? Are you ready for the case to be called?
I believe
We're ready, Your Honor.
Yes.
This is 230799 LT. This is Anmark versus Rogers. May I have your appearances, please?
For the record, Your Honor, Attorney Ian Morton of Palace Law on behalf of the plaintiff Anmark.
George of Lakeshore Legal Aid for Karina Rogers.
Thank you.
If I may, Your Honor?
Absolutely.
Your Honor, this was a matter in which the, was it a judgment, a default, actually a judgment had been taken previously. We appeared at the last hearing. The court entered an order granting defendant's motion to set aside the default judgment with certain conditions. Was it if those conditions were not met, then the order which the court signed on May 10th, 2023 would result in the opportunity for my client to be able to request a default be entered again. The two of the requirements included a deposit of $1,750 into escrow by May 9th, as well as an answer being filed by May 16th. I advised Mr. George of this as well, and according to his records as well, no escrow has been paid and no answer has been filed. So we would be seeking a default judgment for entry today, as I told Mr. George we would be seeking. So I would let him, advise as well.
Mr. Morton's summary was correct, Your Honor. Unfortunately, the escrow order was not complied with by my client. That is why we did not file an answer because we were already defaulted at that point. And we were waiting for the plaintiff to file their affidavit. We don't have any response at this point.
Thank you. In reviewing this matter, the court did note that there had been no answer filed as required in the agreement reached on May 2nd that was reduced to an order on May 10th. There was no escrow, no order. Wasn't sure if the keys had been exchanged, but in any event, the defendant, having failed to comply with the court's May 10th, 2023 order, default judgment shall enter in this matter. Mr. Morton, what is due to the plaintiff?
You're at this time balance due is $5,727.81. Court cost of $164 for a total of $5,891.81. And to clarify for the court as well, this is a possession only action, as was it for the record?
Thank you. If you would submit a judgment with those provisions, Mr. Morton.
Absolutely, Your Honor. We'll submit that. And I will also forward a copy to Mr. George when we submit that as well.
Anything else in this matter, Mr. George?
No, thank you, Your Honor.
Anything else, Mr. Morton?
No, Your Honor.
Thank you very much.
Thank you.
Have a good day.
Thank you, Your Honor. You too.
I'll be here
Thank
at
you,
your
Mr.
11
Morton.
o'clock docket, Your Honor.
I see that. Thank you, Mr. Morton. Oh.
They did it again.
I did, Mr. Horn. I pulled you out because there are people here, and if we can get them off. Have you, I'm sorry. Have you spoken, this is 23195 This is West Village versus Sherry Bergeron or anyone at 38702 Cherokee Drive, number 198. Mr. Horn, this case was scheduled at 9:30. It's now 10:28 by the court's clock. There's no one responding to the call. Defendant having failed to appear, how would you like to proceed?
We'd request a possession default judgment for rent to retain of $1,435.21, cost of $164.60 for a total of $1,599.81, Your Honor.
Thank you.
Thank you.
Defendant having failed to appear, default judgment shall enter with a total due to plaintiff of $1,599.81. Plaintiff's office to submit that judgment for entry. This is 23195 This is West Village versus James Bevel Jr. or anyone at 7008 Abilene Drive, number 314, the city of Romulus. James Bevel. This case having been scheduled at 9:30, it now being 10:29 by the court's clock. Defendant having failed to appear, no one responding to the court call. Mr. Horn, how would you like to proceed?
We would request possession default judgment, Your Honor, rent to retain $2,010.59, cost of $164.60 for a total of $2,175.19.
Defendant having failed to appear as ordered by the court, default judgment shall enter in favor of plaintiff and against defendant with a total due of $2,179.19. Plaintiff's office to submit that judgment for entry. This is 231960 LT. This is West Village Estates versus India Bryant. Mr. Horn, had you had the chance to speak to Ms. McLemore about this matter?
I did, Your Honor. We came to an agreement on a conditional dismissal. I'm going to draft with the following term. It's a single term that Ms. Bryant bring her balance to zero, including rent, utilities, and late fees through June by June 30th of 2023. If not, then we can come back to the court and ask for a writ of eviction under 4B with no further hearings.
Danette
Ms.
McLemore.
you're-
I'm sorry, Danette McLemore appearing on behalf of Indian Bryant, and that is correct, Your Honor. That is our agreement.
Thank you. Ms. McLemore, I've received your appearance in this matter this morning. I saw you sitting there. My apologies for not getting back to you sooner. The court will take the conditional dismissal wherein Ms. Bryant will bring her account to zero by June 30th, 2023 with the 4B provision on the conditional dismissal. Anything else this morning, Ms. McLemore, in this matter?
No, I would like to point out that Ms. Bryant is in the courtroom as well, Your Honor.
I marked her as present in the file, so thank you, ma'am.
Thank you.
Anything else?
No, thank you, Your Honor.
Nothing for
Thank you.
plaintiff.
Good to see you.
You too. Thank you.
This is 231963 LT. This is West Village Estates versus Dustin Henson. Dustin Henson or anyone at 7058 El Paso Boulevard, number 014 in the city of Romulus. Mr. Horn, the court notes your appearance for the record. This case was scheduled at 9:30. It's now 10:31 by the court's clock. Defendant having failed to proceed. Mr. Horn, how would you like to proceed?
We would request a possession default judgment, rent to retain $1,525.90, cost $164.60 for a total of $1,690.50.
Thank you. Defendant having failed to appear as directed by the court, default judgment shall enter in favor of plaintiff and against defendant with a total due of $1,690.50. Plaintiff office to submit that judgment for entry. This is 231964 LT. This is West Village versus Angela Hughley or anyone at 7001 Abilene Drive, number 192 in the city of Romulus. This case was scheduled at 9:30. It's now 10:32 by the court's clock. Mr. Horn, the court notes your appearance for the record. In reviewing the court's breakout sessions, there is no one by that name. There are no unidentified persons. Defendant having failed to appear, how would you like to proceed?
We request a possession default judgment, rent to retain $3,603.27, cost $164.60 for a total of $3,767.87, Your Honor.
Thank you. Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant. The total judgment of $3,767.87. Plaintiff's office to submit that judgment for entry. This is 231993 LT. This is West Village Estates versus Ashley Davenport, Nicholas Gotts, or anyone at 3884 Cody Drive, number 464 in the city of Romulus.
Your Honor, I do appear on behalf of the plaintiff on that one. They paid their balance this morning, and so a submitted dismissal should be on its way.
Thank you, Mr. Horn. The court's made a notation in the file that a dismissal is forthcoming as the tenants paid this morning. This is 232048 LT. This is Park Estates versus Stephen Morgan. Stephen Morgan or anyone at 60 Park Estates Drive in the city of Belleville. Mr. Horn, the court notes your appearance for the record. There are no unidentified persons in the court's sessions this morning. No one responding to the court call. Case scheduled at 9:30. It's now 10:34 by the court's clock. Defendant having failed to appear. How would you like to proceed, sir?
We would request a possession default judgment, Your Honor. Rent to retain, $758.13. Cost $153.60 for a total of $911.73.
Thank you. Defendant having failed to appear is ordered by this court. Default judgment shall enter with the total due to plaintiff of $911.73. Plaintiff's office to submit that judgment for entry. This is 232050 LT. This is Park Estates versus Faris Parton.
Here.
State your name, please.
Faris Parton.
Ms. Parton, have you
And
had the
Brian
opportunity to speak to
Parton, Your
Mr.
Honor.
Horn this morning?
I'm sorry.
Have you had the chance to speak to Mr. Horn this morning?
Yes, we have. Yep.
Mr. Horn, how are we proceeding in this matter?
Your Honor, we met prior to today's hearing and we've come to an agreement on a consent judgment. Rent to retain is $640.46. Cost of $153.60 for a total of $794.06 to be paid on or before June 5th of 2023. I did explain their rights under MCR 4.201 subsection I, and I secured permission from Ms. Parton to add their name with permission to the agreement as stated on the record today.
Ms. Parton, you were able to hear Mr. Horn just now?
Yes.
And it's your understanding and agreement to a consent judgment that $794.06 is due and owing?
Yes.
And because you're not represented, you understand that this judgment may be set aside should you file a motion within 3 days with the court?
Yes.
And that you have 10 days to appeal the judgment?
Yes.
And because you appear by Zoom, there is not a signed judgment. Have you authorized Mr. Horn to sign your name to a consent judgment?
Yes.
Mr. Horn, did you make an indication that Brian Parton was being added?
Your Honor, they're not a named defendant and there's no specific,
Okay.
so I didn't add their name because I didn't want to overstep.
It's not an overstep, is your case. Did you want to specifically identify him or not?
I would not at this point because it does cover all other occupants as well. I do appreciate that he's here and also stated his willingness, but he's not a named defendant at this time.
I appreciate that, Mr. Horn. If your office will submit that judgment to the court for entry, I'll sign it, and Ms. Parton, a copy will be mailed to you at the address we have on file. Do you have any questions this morning, ma'am?
No.
Have a good day.
Thank you. You too.
Thank you. This is 232057 LT. This is Park Estates versus Kayla McDonald.
I'm here.
Your appearances, please.
Danny Horn, PA 1774 for plaintiff.
Kayla McDonald.
Today is the day and time set for the second hearing in this matter. Mr. Horn, how are we proceeding this morning?
Your Honor, we've agreed to a consent judgment. At this time, rent to retain possession is $9,048.50. Costs are $153.60 for a total of $9,202.10. Ms. McDonald has indicated that they will be moving out and vacating prior to June 5th, 2023, which is the statutory period. I've explained their rights under MCR 4.201 subsection I, as well as asked them for permission to add their name to this agreement as stated on the record and submit to the court.
Thank you. Ms. McDonald, you were able to hear Mr. Horn just now?
Yes.
And it's your understanding that a consent judgment will enter where a balance of $9,202.10 is due and owing?
Yes.
And that you will pay this amount or vacate by June 5th, 2023?
Yes.
And Mr. Horn explained to you that this judgment may be appealed within 10 days?
Yes.
And that the judgment will not be final and enforceable for 3 days?
Yes.
And because you appear by Zoom, there is not a signed judgment in the file. You've authorized him to sign your name to that judgment.
Yes, I do.
Do you have any questions, ma'am?
No, I do not.
Mr. Horace's office will prepare and submit that judgment to the court for entry. I'll sign it and a copy will be mailed to you at the address we have on file. Thank you for your patience this morning. You have a wonderful day, okay?
Thank you, Your Honor.
Thank you. This is 231966 LT. This is West Village versus Kelly Kirkland. May I have your appearances, please?
Danny Horn, PA 1774 for plaintiff.
I'm here.
Kirkland.
Yes, ma'am, I'm here.
State your na-
Kelly Kirkland.
Today is the day and time set for the second hearing in this matter. Mr. Horn, how are we proceeding?
Your Honor, we're proceeding with the consent judgment. Rent to retain is strike that, $1,371.17. Costs are $164.60 for a total of $1,535.77 payable on or before June 5th of 2023. I did explain to Ms. Kirkland their rights under MCR 4.201 subsection I, as well as asked and got permission to add their name to the agreement with the terms stated on the record.
Sir, I have a question.
Let me do this part first and then you can ask your question.
Okay, yes, ma'am.
Ms. Kirkland, was your understanding that a consent judgment would enter with a total due to the plaintiff of $1,535.77?
That is correct.
And because you appear by Zoom, there's not a signed judgment. You authorize Mr. Horn to sign your name to that judgment.
That is correct.
And he explained to you that the judgment may be appealed within 10 days.
That is correct.
And that because you're not represented, the judgment would not be final and enforceable for 3 days.
Correct.
What was your question, ma'am?
My question is, did that include June's rent?
It does not.
It does not. Is there some way I could probably come up with all of that by the 5th, but can I have 2 weeks after that for June's rent without her charging me a whole bunch of other fees? Or just the late fee and not the court cost?
Ma'am, we can't negotiate on the record. You can try to work something out with the property, and that's separate and apart. That June rent is separate and apart from this judgment because this only goes through May.
Okay, no problem. Thank you.
You're welcome.
Thank you. Any other questions about this morning's case, Ms. Kirkland?
No, ma'am.
Ms. Samples is here I see her on the session. If she wants to go into a breakout room and talk, that's fine, but I cannot negotiate future rent.
Your Honor, she can just call me when we end this call. That'll be fine.
All right, thank you. I will call you.
Thank you, ma'am.
Ms. Samples.
Thank you, Ms. Samples. Thank you, Ms. Kirkland.
Thank you. Have a good day.
You too. Ms. Pearson, I interrupted your conversation with Mr. Horn because my 9:30 cases were still hanging around here. Had you finished talking or did you need to go back in?
We needed to go back in.
No.
Go back in with him. I'm going to take a brief recess, but I'll be right back out. I see other people here.
Thank you.
Thank you. Miss. Oh. Miss Austin.
Your Honor.
Ma'am, how are you this morning?
I'm good. How are you, ma'am?
I am super. Have you spoken to Mr. Jackson?
I have spoken with Mr. Jackson.
Are you ready for the case to be called?
I am.
Let me just find the file. This is 232037 LT. This is Tuscan Manor versus Raymond Jackson. May I have your appearances, please?
Good morning, Your Honor. Rebecca Austin, appearing on behalf of plaintiff.
Good morning, Your Honor. Raymond Jackson is here.
Thank you. Today is the day and time set for the second hearing in this matter. Miss Austin, how are we proceeding this morning?
Your Honor, I had the opportunity to speak with Mr. Jackson. We had the terms of the consent judgment to place on the record.
Those terms, please.
Your Honor, rent to retain is $2,360. There are court costs of $159.50 for a total of $2,519.50. Mr. Jackson is going to pay $1,300 by June 6th. He's going to pay the remaining $1,219.50 plus June's rent and June's late fee by June 30. And Mr. Jackson did give me permission to sign his name to the consent judgment with those terms.
Mr. Jackson, were you able to hear Ms. Austin just now?
Yes, ma'am.
And it's your agreement and you wish to enter a consent judgment that says that $2,519.50 is due owing the plaintiff in this matter?
Correct. Yes.
And that you'll pay $1,300 by June 6th?
Yes.
And then the $1,219.50 plus June's rent and late fee by June 30th.
Yes.
And because you appear by Zoom, there's not a signed consent judgment. Have you authorized Ms. Austin or her office to sign that consent judgment on your behalf?
Yes.
And did Ms. Austin explain to you that this judgment may be appealed within 10 days?
Yes.
And that because you're not represented and they represent Belleville Point, that you can come in within 3 days and file a motion that sets aside these consent judgment.
Yes.
Mr. Jackson, do you have any questions this morning?
Will I get all this in the mail?
Yes.
Okay, that's all I need.
What will happen now is Ms. Austin's office will submit that judgment with the terms that we just placed on the record, submit it by email, I'll sign it, and then the court will mail a copy to you at the address that we have on record, okay?
Okay.
Anything else?
Nope, I'm good.
Have a good day, Mr. Jackson. Thank you for your patience.
All right, you too, Your Honor.
This is 232038LT. This is Belleville Point Apartments versus Janice Randall. May I have your appearance, please?
Good morning, Your Honor. Rebecca Austin, and on behalf of Bell Point.
Good morning, Your Honor. Janice Randall.
Today is the day and time set for the second hearing on this matter. Ms. Randall, have you spoken to Ms. Austin?
Yes.
How are we proceeding this morning, Ms. Austin?
Your Honor, we have the terms of the consent judgment placed on the record.
Yes, please.
Rent to retain in this case is $2,506.50. There are court costs of $159.50 for a total of $2,666. Ms. Randall indicates that she'll be able to pay this by the June 5th date. And she has given me permission to sign her name to the judgment.
Ms. Rand, it would help if I wrote in the right file. Ms. Randall, you were able to hear Ms. Austin just now?
Yes.
And ma'am, is your agreement and you intend to enter a consent judgment that shows that a total of $2,666 is due and owing to the plaintiff?
Yes.
And that you will pay this amount or vacate the premises by June the 5th, 2023?
Yes.
And that because you appear by Zoom, there's not a consent judgment. Have you authorized Ms. Austin to sign your name to a consent judgment?
Yes.
And ma'am, you understand that you have 10 days to appeal this judgment?
Yes.
And because you're not represented, you have 3 days to come file a motion with the court asking to set aside the terms of the consent judgment.
Yes.
Do you have any questions this morning, Ms. Randall?
No, not at this time.
Thank you. Ms. Austin's office will prepare a consent judgment with those terms, email it over to the court. The court will sign it and a copy will be mailed to you at the address we have on file. Thank you for your patience, Ms. Randall. You have a wonderful day.
Thank you, Your Honor.
Ms. Cheatham, this is 232043LT. This is Belleville Point versus Cheatham. May I have your appearances, please?
Yes, Kamira.
Good morning, Your Honor. Rebecca Austin, on behalf of plaintiff. I did not have the opportunity to talk to Ms. Cheatham. I think she just joined late.
Yeah, I was late. I'm sorry. I'm at work.
No, Ms. Cheatham, it's fine. You'll see an invitation to go into a breakout room with Ms. Austin. Please go there, talk to her about the case. You'll come back out. I'll get your case recalled, okay?
Okay, thanks.
Thank you. This is 231985LT. This is West Village versus Pearson. May I have your appearances, please?
Danny Horn, 1774 for plaintiff.
Taylor Pearson.
And where is Preston Pearson?
He's currently asleep right now. He works nights.
I'm Haley Lorenzen. I am on the lease.
Today is the day and time set for the second hearing in this matter. The parties have had an opportunity to speak. Mr. Horn, how are we proceeding?
Your Honor, there's no dispute over the amount that's due at this time. There's an agreement that rent to retain is $3,226.73. Costs are $199.20 for a total of $3,425.93. The only issue is we've proposed the 10-day standard and they are seeking more time.
I'm sorry. I love toddlers as much as anyone else, but I can't hear over him or her. If one of you could take the baby away, or if there's somewhere else.
Yes, let me go put him down. I'm sorry.
The agreement is to $3,429.93. The disagreement is what, Mr. Horn?
$3,425.93. The disagreement is to the amount of time to pay. We have authority for the normal statutory period. They're requesting extra time. Believe that they have an SER application at this point. Our position is the SER does not put a stay on anything at this point in I guess the end of the pandemic. And so we're requesting judgment today. We wanted to talk to you, Your Honor.
I'm sorry. So how much extra time?
I'm sorry, how much what?
How much extra time are you asking?
I'm so sorry. Excuse me. So like I'm not sure. I wasn't sure if the SER granted more time or not. I know from previous court hearings and overhearing certain things like the Sarah granted the 45-day stay. I had applied for ERAP at one point, which granted the 45-day stay. And the ERAP was, it only paid like a fourth of the amount, which, was more than appreciative of the help that we were able to get. All of this was due to being on bed rest for like my entire pregnancy from the baby that you just heard.
Do you remember what my question was to you?
Yes, the time. How much time?
How much more time do you need than 10 days?
Well, I wasn't sure if the SER granted any extra stay, like the time, like the ERAP and the Sarah did.
I'm asking you for a number, because if Mr. Horn is saying 10 days and you're saying 20, then I'll say, Mr. Horn, come on. If Mr. Horn is saying 10 days and you're saying 60, that's a different kind of conversation. So I'm looking for a number from you.
20 to 30.
I'm looking in the court file. The complaint indicates that rent hasn't been paid since January 31st, 2023, 20 to 30 days without some explanation or some better understanding. Mr. Horn, how far out is your client willing to go? Or is it just the 10 days?
Your Honor, at this point, my client's only willing to go the 10 days. I will say in our discussions, there was no actual definitive timeline given. It was just an open-ended request. So 10 days is where we landed with my client.
I'm sorry, for the tenants, do you admit and acknowledge that there's $3,429.93 due owing in this matter?
Yes, ma'am.
Are you able to pay any amount of money by June 5th, which is 10 days?
Yes.
Here's the issue, because you admit and acknowledge that amount of rent due and owing, including the court costs, is what has just been placed on the record. There is not a triable issue, and the plaintiffs are entitled to entry of judgment in that amount. I said, Mr. Horn, it is $3,425.93.
That's correct, Your Honor.
And the court would enter a judgment in that amount. The court does not typically get involved in payment. How payments will be made, you heard it earlier, in a much larger balance. And that is something, the payment plan is something that you can discuss directly with Ms. Samples or some other representative in West Village Estates. but given the amount of back due rent in this matter, the court is not staying these proceedings for a SCR application, but would encourage you to talk to management regarding a payment plan that includes payments before 30 days out. I just don't think that's reasonable, given the fact that there are 2 people named in this complaint and someone else being involved in this matter. If that's clear to you, Ms. Pearson?
Yes.
Okay. So Mr. Horn, if you would submit a judgment after hearing the amount of rent due and owing in this matter as you've placed on the record, and the tenants will be in contact and communication with a representative from the office regarding payment terms. Anything else, Mr. Horn?
Your Honor, just to indicate on the judgment that I will submit to the court as defendant 2, it would be a default. I've put that in the further orders only as to Preston Pearson III.
Ms. Pearson, did you have any questions?
No.
Okay, it will be after hearing as to defendant 1, default as to defendant 2. It will have the statutory 10 days in there, but Ms. Samples is on. You may speak to her about a payment plan. Again, the court does not get involved in payment plans, but usually the court finds that plaintiffs are willing to work with people who are making payments, even if it's not within that 10-day period. Just do something to kind of move this matter along, okay?
Okay.
Anything else?
Nothing further.
Have a good day. Thank you.
Thank you.
Thank you, you too. So SCR.
Is 231967 LT West Village Estates versus Albrecht Lawrence.
Danny Horn for the plaintiff, Your Honor.
I'm sorry, Mr. Horn, I have loose papers up here, which you don't put them back where they belong, they'll stay forever lost.
No, that's quite all right, Your Honor.
Case was scheduled at 9:45, is now 10:56 by the court's clock. Lawrence or anyone at 38970 Cherokee. There are no unidentified persons in the court's virtual session. Defendant having failed to appear, there being no response to the court call. Mr. Horn, how would you like to proceed?
We would request a possession default judgment. Rent to retain is $1,561.87.
Wait, I'm sorry.
Of course. $1,561.87. Costs $164.60. Total is $1,726.47.
Thank you. Defendant having failed to appear as directed by this court. Default judgment shall enter in favor of plaintiff and against defendant with a total due of $1,726.47. Plaintiff's office to submit that judgment for entry. This is 231972 LT. This is West Village versus Kurt Starsky or anyone at 6983 Shawnee Drive, number 297 in Romulus. This, Mr. Horn, the court notes your appearance for the record. There are no unidentified persons in the court's virtual session. No response to the call. Defendant having failed to appear. How would you like to proceed?
We'd request a possession default judgment. Rent to retain, $822.02. Costs $164.60 for a total of $986.62, Your Honor.
Thank you. Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with a total due of $986.62. Plaintiff's office to submit that judgment for entry. This is 231974 LT. This is West Village Estates versus Courtney Watts or anyone at 38625 Cody Drive in the city of Romulus. Mr. Horn, the court notes your appearance for the record. This case is scheduled at 9:45. It's now 10:59 a.m. by the court's clock. Defendant having failed to appear, there being no response to the call. How would you like to proceed?
We request a possession default judgment. Rent to retain, $1,737.32. Costs $164.60. Total $1,901.92, Your Honor.
Thank you, sir. Defendant, having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with a total due of $1,901.92. Plaintiff's office to submit that judgment for entry. This is 23197 LT. This is West Village Estates versus Jerisha Williams. Ma'am, unmute yourself and state your name for the record for me, please.
Good morning, Jerisha Williams.
Thank you. Have you spoken to Mr. Horn this morning?
Yes, ma'am.
Mr. Horn, how are we proceeding?
We are proceeding with a consent judgment, Your Honor. Rent to retain is $1,561.09. Costs are $164.60 for a total of $1,725.69 to be paid on or before June 5th of 2023. Because they are unrepresented, I explained Ms. Williams' rights under MCR 4.201, and I did ask and get permission to add their name to this agreement with the terms stated on the record.
Thank you. Ms. Williams, were you able to hear Mr. Horn just now?
Yes, ma'am.
And it's your agreement that you will be entering a consent judgment that has a total of $1,725.69 owing to West Village Estates.
Yes, ma'am.
And Mr. Horn explained your rights to you regarding your appeal and your 3-day period before
Yes,
the
ma'am.
judgment's final and enforceable. And
Yes,
because you
ma'am.
appear by Zoom, you've authorized Mr. Horn to sign your name to that consent judgment.
Yes, ma'am.
Any questions this morning, Ms. Williams?
No, ma'am.
Mr. Horn's office will submit a consent judgment with those terms. The court will sign it and the copy will be mailed to you at the address we have on file. Thank you for your patience this morning, ma'am. You have a wonderful day.
You as well. Thank you.
Thank you.
Bye-bye.
Mr. Horn, is that it for you, sir?
That's it for me, Your Honor. Thank you for working through that long list.
Thank you so much. You have a good day. Good to see you.
You as well. Thanks.
This is a recall of 232043 Belleville Point versus Cheatham.
Good morning again, Your Honor. Rebecca Austin here on behalf of the plaintiff.
Ms. Cheatham, you've had a chance to speak to Ms. Austin.
Yes.
Ms. Austin, how are we proceeding this morning?
Your Honor, I have the terms of a consent judgment to place on the record.
Yes, ma'am.
Rent to retain is $1,160. Court costs of $159.50 for a total of $1,319.50. Ms. Cheatham is going to pay $1,000 by June 5. She's going to pay the remaining $319.50 plus June's rent and June's late fee by June 23rd. And she has given me permission to sign her name to the judgment.
Ms. Cheatham, you were able to hear Ms. Austin just now.
Yes.
And ma'am, it's your understanding and agreement to entry of a consent judgment that shows a total of $1,319.50 due and owing to the plaintiff,
Yes.
and that you will pay $1,000 by June 5th, 2023, and then $319.50 plus June and June's late fee by June 23rd.
Yes.
And ma'am, you understand that you have 10 days to appeal entry of this judgment.
Yes.
And that, I'm sorry, I said 10 days to appeal the judgment and then 3 days to ask the court to set aside the terms of the consent judgment because you are unrepresented.
Yes.
And ma'am, because you appear by Zoom, there is not a signed consent judgment. Have you authorized Ms. Austin to sign your name to the consent judgment?
Yes.
Do you have any questions, Ms. Cheatham?
No.
Ms. Austin's office will submit a judgment to the court by email. The court will sign it and the copy will be mailed to you at your address on file with the court. Thank you for your patience this morning, ma'am. Have a wonderful day.
Thank you. You too.
Thank you. This is 232044 LT. This is Belleville Point versus Michael Harvey. May I have your appearances, please?
Good morning, Your Honor. Rebecca Austin, appear on behalf of the plaintiff.
Mr. Harvey,
Yes.
turn your video on and state your name for me, please, sir.
Let's see. How do I turn the video? I see the tab for the video.
Mr. Harvey, have you had a chance to speak to Miss Austin this morning?
Yes.
Miss Austin, how are we proceeding in this matter?
Your Honor, I have the terms of a consent judgment to place on the record.
Thank you, ma'am. Yes.
Your Honor, hi, Mr. Harvey. Rent to retain in this case is $2,440. There are court costs of $159.50 for a total of $2,599.50.
I'm sorry. Over there and I'm sorry, 2,500.
99.50.
Thank you.
And Mr. Harvey is going to pay that by June 5th, and he has given me permission to sign his name.
Mr. Harvey, you were able to hear Miss Austin just now.
Yes.
And sir, it's your agreement that a consent judgment will enter showing that $2,599.50 is due and owing to the plaintiff in this matter.
Yes.
And that you will pay this amount or vacate the property by June 5th, 2023.
Yes.
And that because you appear by Zoom, there is not a signed consent judgment. Have you authorized Miss Austin to sign your name to that consent judgment?
Yes.
And sir, you understand that you have 10 days to appeal entry of this judgment?
I'm sorry.
You understand that you have 10 days to appeal entry of this judgment?
Yes.
And because Ms. Austin represents your landlord, you are unrepresented, the judgment is not final and enforceable for 3 days.
Yes.
Do you have any questions this morning, Mr. Harvey?
No, I don't.
Ms. Austin's office will prepare a consent judgment with the terms that we just placed on the record. The court will sign it and a copy will be will be mailed to you at the address we have on file. Thank you for your patience, Mr. Harvey. You have a good day.
You as well. Thank you.
Thank you, sir. Ms. Austin, that's it for you, correct, ma'am?
It is, Your Honor. Thank you so much.
Thank you. You have a good day.
Yeah, you too. Thank you.
Sandy, thank you so very much. Take care.
Thank you, Judge.
Mr. Martin, Mr. Morton is here with his witness. I am stepping off for a moment being less than 3 minutes. I'll be back out and I'll be ready to call your case, okay?
Can you hear me?
This is 231712 LT. This is Harbor Club versus Scott Martin. May I have your appearances, please?
For the record, Your Honor, Attorney Ian Morton of Pallets Law on behalf of the plaintiff.
Mr. Martin, state your name for me, sir.
Scott Allen Martin.
Mr. Martin and Mr. Morton, today is the day and time set for the adjourned trial in this matter. We started last week with Ms. Burgess' testimony, and Mr. Morton started to share the lease and the ledger. Mr. Martin raised an objection that he had not had the chance to review the ledger. The court printed out the exhibit submitted by Mr. Morton. A copy was provided to Mr. Martin. Mr. Martin, you received and reviewed that information?
Yep.
Yes?
Yes.
And were we ready to resume the trial that started on the 17th?
Yes, Your Honor.
Okay,
Yes.
we were at Ms. Burgess' testimony. Ms. Burgess, raise your right hand, ma'am. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. We were at your testimony regarding the repair request and the ledger. Mr. Morton, if you want to resume where you were, sir.
Thank you. Do I have permission to share my screen for the ledger, Your Honor?
Yes, sir.
Thank you. The court will see in front of it what we had proposed as plaintiff's proposed exhibit number 2, which was the ledger. This is the last page of the ledger. Ms. Burgess, was it? I know you had testified previously at the last date, but the ledger before you, was it? Who is this ledger for?
Scott Martin.
And was it, as I said, I'm going to restate a few different things, or have you restate a few different things that was said the last time. But this is a document that's kept in the regularly conducted business of the plaintiff. Is that correct?
Correct.
And it signifies payments that are made and then are accounted for on this ledger. Is that correct?
Correct.
And then charges that you are, that you put on Mr. Martin's, account, and those are reflected on this ledger as well. Is that correct?
Correct.
Additionally, if I may draw, you'd also said before that there has been multiple incidences in which you had provided credits on this account. Is that correct?
Correct.
And one of them was on March 3rd. Is that correct?
Correct.
What was that March 3rd credit for?
A late fee.
And then there was another credit that was issued on March 22nd as well. What was that credit for?
Lease violation.
Okay. And then I'm going to scroll up slightly. You said that there was also, was it a late fee that was not charged for 1 month? What month was that?
September.
Okay. And so that was not charged at all?
Correct.
Okay. Your Honor, again, we would move for entry of the ledger as a business record showing the accounting, of the balance that is due. And I would just state for the record that I know Mr. Barton has had a chance to review it. While he might disagree with some of the charges, it is a document to go to show the balance that my client has created based on its business records.
Mr. Martin, do you have any objection to the court receiving the ledger, which is plaintiff's number 2, the resident ledger? Do you have any objection to the court receiving it as a business record?
I don't understand what that means.
It's Ms. Burgess' testimony is that this is a document that's kept in the regular and ordinary course of business. And Mr. Morton has moved that it be admitted to be considered as evidence in this matter. Do you have any objection to the court receiving it?
No.
For those purposes?
No.
Okay.
No.
Then number 2 is received. Thank you, Mr. Morton.
And then again, I know I've probably repeated myself a few different times when it comes to things that we did before, but Ms. Burgess, does the balance stated on the ledger show the accurate amount that's currently past due and owing?
Correct. Yes.
And then what is the current total balance that's past due and owing at this time?
$667.
And is that inclusive of the court costs as well?
Correct.
And those core costs are $167? Okay.
Correct.
Your Honor, unless the court would like to, or was it, I know that both other parties have copies of ledgers. I was going to stop sharing my screen.
Yes, please stop sharing your screen.
Ms. Burgess, was it, we had also stated before, was it in anticipation of statements that Mr. Martin may make? Was it, you have was the community recently responded to, was it work order requests from March of this year? Is that correct? And what were those work orders for?
I am pulling it up again. I'm sorry. Hold on. A wobbly toilet, missing the kitchen drawer and main bathroom drawer, needs 3 blinds, and this one says wants carpet changed.
And then what did the community do after receipt of that?
We replaced the toilet, replaced both of the drawers, and I'm not 100% certain if they replaced the blinds because whoever did the work order didn't add it in the notes. And that is it.
At this time, you're asking for a judgment totaling $667. Was it be entered today for possession? Thank you.
Correct.
Your Honor, no further questions at this time.
Thank you. Mr. Merton, do you have any questions for Ms. Burgess? Not your testimony just yet, your questions, sir.
No.
Thank you. Thank you for your testimony, Ms. Burgess.
Thank you.
Mr. Morton, your next witness, sir.
Your Honor, I have no other witnesses to present at this time. I rest my case.
Thank you. Mr. Martin, do you have any witnesses other than yourself, sir?
No.
Mr. Martin, raise your right hand for me, please, sir. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Are you under our front foyer stairs?
Yes. You want
Is
me
there
to
someone
move?
in the Zoom room? No, I want you to be able to hear me and me hear you. Is there someone
Yeah.
in the Zoom room to your right?
Yeah, there's that's why I couldn't go in there because the gentleman at the office did this on my phone, and I'm just trying to get in the area where I can hear you and not to be distracted. So I'm in the corner. There's nobody here.
If you're good there, then I'll start taking your testimony.
Yeah, I'm good here. Yeah, I'm
Okay.
comfortable.
Your response to the complaint in this matter, your response to the allegations.
No, because that's just going to lead into another argument. Your Honor, I'm here because of 4 late charges. My testimony is the first error comes in when we first started doing the lease. The numbers are all jiggy rigged around. And that's where the first mistake was on them, because like I said before in my other testimony, that the app that they made you pay the rent on was a Habitat app, only said I think it was like 986 or something, but it was paid. But that's where the first late charge come from. The second one was because of the credit card fraud, that I had the money, but I couldn't do it because I had to wait to go to disputation to the bank. And that happened twice. That would be 3 late charge total. And this is the reason why I reached out to them to go to the office, and no one can do anything but Lindsay. And that took a long time to be able to talk to her, which I was never able to do. That's why I left my phone number. They made no attempt to reach out to me before it even went this far. They just seemed like they played a game and let this accumulate to make this attempt on me. And the one that I said before that I was saying, I'll be honest, because I'm not trying to get away with nothing, was when I went through that incident with the car, and that would have been the 4th late charge. So that would have been a total of $400. That's exactly what the paperwork says, 400 plus when we started all this. And 3 of them, that was what I was asking for to solve in the office. But when I got the eviction notice, Lindsay shared with me she couldn't do anything because the paperwork was already filed. That was when we spoke. Now, what she's talking about with the insurance thing is you need renter's insurance. We both, I did this in front of her. We both called the renters right in front of each other's, and it took 2 tries to get that to her. And when we finally got that over, I think that's what she meant by that's what she erased for the late charges, which she did. And that's why I don't want to go into that discrete or arguing or anything. I just want to focus on the 4 late charges, the 3 reasons why. One was just their fault and she corrected it, but the late charge was never dropped because the paperwork was already filed into here. So I had to wait to come to court to bring it to your attention. And the one that I'm being honest on was the car. Actually, there should only be $100 late fee charge, which I said I was willing to pay. But I wanted to go through all this because I wanted to see where this was going to go, because I couldn't make no headway with them in the office. And I just think it's a desperate attempt to just get more money out of me or not give me my security deposit or whatever when my lease is up in August. And this is the 3rd time they have switched ownership. So it's easy for them to hide the fact that for 5 years I have lived there, which I've never missed rent. And the furthest I've ever been late was only on these incidents that occurred to me and never went past the 3rd or the 5th. That history should prove and show that to be true. 5 years is a long time to show loyalty. Now the carpet, I've never gotten new carpet. It's the same original carpet that I had 5 years ago. And for me to pay full rent and never receive anything like that. And I didn't, the toilet, they're just throwing that in because I just got the toilet. And then that was just last month, they just gave me the toilet. But like I said, I've been there for 5 years. It's easy to disguise that work order paperwork when you shift your staff 3 different times and there is nobody in that office, which was originally there 5 years ago. Lindsay is the only one. And that's it. I'm just asking for honestly to pay my $100 unless you find it grace that I've always paid my rent. And I just ran into a little dip of a hard time. I just needed a new week. And unless you would like to dismiss it all, but I will pay the 100 because that's my fault. And it's not Mr. Morton's fault. Now, replying back to the credit card fault or problem, I understand it's not Mr. Morton's fault either. And this is his establishment and business. I understand that, but it's also not my fault. I was at the mercy of what the bank had to put me through the process. And that's really all I'm asking for. Not no added in court costs because I'm missing 6 hours of work having to come here 3 times, which equals out to the same amount of money. And that's it. So I was either wanting to ask all of it to get dismissed, or honestly, I should only be charged $100 for late fee. Everything else is kind of easy to manipulate the time frame in. And it's just a little coincidence that I've never had a problem until this new ownership came for this one solid whole year. I've had no late charges prior to that other than to this late year. And I've been there for 5 years. So I've never, ever made any attempt to neglect not paying rent. It was only because of the troubles that I went through and the difficulties that gave me a couple days later past this policy date, which is the 2nd, when rent's due on the 1st. That's pretty steep. There's no leeway at all. It's just one day. So I'm not a rich guy. I depend on my checks, and sometimes you have to make a decision what's best for your situation when you're living from check to check. And I thought I did a pretty good job getting them their rent, even though I went through those difficulties, being only maybe 2 days later to the 5th, which would be 3 days late. And that's about it. I mean, that's all it really is. The renter thing is you have to have renter's fee, and her desperately making that as an attempt. Why did she wait 9 months, and why didn't she do that when we first did the lease? Because I've always had renter's insurance. You have to have it. I don't even know what that's about. We fixed that in the office, and she was there with the phone call with me. We did it together. That's it. That's really all it is. I don't want to get into all this other ridiculous stuff. And that's it, Your Honor.
Mr. Morton, do you have any questions for Mr. Martin?
No, I do not, Your Honor.
Thank you. Mr. Morton, I have I have two, maybe three questions.
Certainly.
Would your client accept rent after I was going to ask, would your client accept rent after the case started, but I see that there was rent paid on the April 5th and April the 2nd. Okay.
Yes,
I'm
Your
sorry,
Honor. So
May the
my
2nd.
client regularly accepts rent. Was it after with an active case going? I know many clients and some of my clients do not accept rent and will only accept the balance paid in full, but this client will accept payments. Was it as the case is active?
The other question that I had in reviewing the ledger was the $100 per month late fee. Mr. Martin, in his testimony, indicated that that seems pretty steep for being a day or maybe too late. And in looking at the ledger, seeing that Mr. Martin's tenancy goes back to 2017, and he routinely had zero balances, the issues just appear to have started recently. $100 sounds pretty steep for a late fee. How does your client justify that?
Was it, I mean, we can take some additional testimony, Your Honor, but the way my client justifies that is because of the administrative costs related to the fact that, was it when the account is past due, they're responsible to be able to follow up on the account, to be able to find out what the status is and to be able to communicate on these things. If you look at when the past due balance in this specific case became past due, it became past due and, look, I can't speak to some of the hardships that Mr. Martin has provided testimony on, but I can speak to the fact that just looking at the ledger itself, it started off when the payments were originally short the full amount, and then there was the NSF payments, was it of that nature. In regards to the late fees themselves, was it my client has deemed based on their investigation and the work that they have to do when it comes to the administrative portions of reviewing the ledger, because every month they have to review these accounts every month that they're past due. Was it because they then have to be able to communicate with corporate, communicate with the owners, and communicate with what's going on about these past due balances. So that is one of the reasons why there's this consistent charge of $100 for late fees that do incur. And of course, Your Honor, it's that way across the board. All the tenants are being treated equally. Nobody has different amounts that are being charged. And then depending on the specific circumstances, in some instances, amounts will be waived, i.e. The waiver that was done in the month of March and the initial non-charge that occurred back earlier in 2022 when they did not charge a late fee at all.
Thank you. Mr. Martin, anything else?
No, I don't have nothing else to say. That's all that is what everything that I said.
Anything else, Mr. Morton?
No, Your Honor.
Thank you. The court did have the opportunity to review the lease and the ledger that was submitted to the court back on May 17, 2023, and hear the testimony from the parties this morning. And Mr. Morton, the court finds $100 per month to be excessive for late fees. And I understand that your client has administrative responsibilities that come due when a tenant does not pay timely, but the court will not allow the late fees that were accrued in April and May as this matter was ongoing. So the court will enter a judgment that includes your court cost of $167 with the principal amount. I don't care if your client, how they apply it as rent or late fees of $300. So a total judgment of $467 if your office will be kind enough to prepare a judgment after hearing with those amounts on it. And as soon as the court receives it, Mr. Martin, the court will sign it and mail a copy to you at the address we have on record.
Thank you very much, Your Honor. I'll submit that to the court today so the court can process that.
Thank you, Mr. Morton. Thank you, Mr. Martin, for your patience this morning, sir. Have a good day.
I had a question.
Yes, sir.
I pay $467.
Yes, sir. And that brings the account to zero with June rent being due in June.
All right.
What's your question, Mr. Martin?
That was it.
Okay. Thank you, sir.
Yeah.
Lindsay, you can log off now.
Okay, thank you. Bye.
Bye, Ms. Burgess.
How do I log
No,
on?
they're on Zoom. I'll put you out, Mr. Martin, it's fine.
I don't know how to do this.
You're okay. I'm taking care of it. Yeah, the interpreter's in the hallway. Would you turn this on for me, the big one on, please?
It's gonna be on Zoom now?
They were supposed to be live, but since they're not, and he's here, she's here.
Just she.
She's here. Yeah, bring her in, please, and turn the screen on.
I guess Steve announced it last night.
Found out what last night?
That it was today, thought it was tomorrow.
Okay, he's here, and Mr. Roberts is here.
Bring the interpreter.
Yes, please.
Yes.
Good morning. How are you?
Good
I'm gonna have
morning.
you
How are
come
you?
up to this podium in the middle right here. Your name, please?
My name is Rose Benacki.
Would you spell your last name for me,
B as in
please?
boy, O-N-A-C-C-I.
Ms. Benaki, what I will do is the thing that you're standing at swivels. If you would swivel it around and face that camera, please.
Is this, is it Johnny Roberts? I don't know.
It is. This is two 4838 LT Royal Village versus Johnny Roberts.
Okay, I'm gonna ask.
Morning, Your Honor.
Johnny, can you see me or you need me closer? Is there any way the camera can zoom in on me? Oh, no, go down. Let me take my badge off.
Oops.
Can you see us?
The screen is very dark.
Linda,
Yes, your screen is
Linda.
very dark.
do you see us?
Yes,
Huh?
I can see you, but your screen is very dark.
I don't know what's wrong with it.
Turn a lamp on. You need
Yeah,
a
are we in
light.
front of the judge?
Yes, this is Judge Martin. Who is there with Mr. Roberts?
John Roberts, his son.
Where is Mr. Roberts?
He's right here. He's beside me.
Is he able to see Ms. Benaki?
Say again. Hey,
There is
can you
an
hear me?
ASL interpreter here. She is signing for him. Is he able to see her?
No, we can't. We can't see the woman. Can we? Talking.
Do you see a woman on the screen with a black jacket?
I got. No. I can translate. I interpret.
No, we went over this before. Here is the problem. Nope. Here is the problem.
Okay.
This case is scheduled now for the 4th time for trial for termination of tenancy. The court has secured an interpreter. Mr. Robinson is here. His witness is here.
He doesn't,
Mr. Roberts, the younger, you need to set this device that you're using up somewhere where the interpreter can see Johnny Roberts, the tenant, and he can see her.
yes. Yes,
But she cannot see him.
I can't do nothing about that. I've been working on the screen here and the picture don't seem to be getting no better.
Are you on a phone or on a tablet?
I'm on a phone.
Is there someplace in the house with better light, a kitchen with maybe an overhead lamp, or a bedroom with a bright light?
Let me see. I need to turn on a light here. Better.
Mm-mm.
But still.
Maybe open your curtain behind you. By opening your curtain behind you.
Wait, who else is there?
That's my client, Judge. Oh.
She's like in half the video. It's not taking a full video of her. She needs to move over the other way. Yes, there you back up, right? And to the left. The other, no, the other way. Right there. He said yes.
I know.
I translate just as well as she does.
Mr. Roberts, we had this, Mr. Roberts, the younger, we had this conversation. You cannot be the translator. The court has secured a translator. If you are not going to make Mr. Roberts available by Zoom, he will have to come here to the court.
Goodbye.
Judge, the interpreter is muted also.
What now?
She's not muted, sir. She's just not talking.
Oh, I'm sorry, Judge.
They have both their cars at home. Can't they drive to the court?
I don't recall asking you a question, actually, honestly.
Sorry.
I know. I'm with you. My inclination, because of how we schedule this, they are 10 minutes away. I know. I appreciate that. And now they're gone. So, Mr. Robinson, not getting into the meat of the case, but I'm not sure. We were scheduled last week, and I had asked for this to be live because I know of the Mr. Roberts, are you able to come physically to the courthouse?
Well, he won't go without me, and I'm sick, and I'm coming with him.
Court did call the case. We have Ms. Rose Manaki. Ms. Manaki, raise your right hand and repeat after me, please. Do you swear or affirm that you will translate English into ASL and ASL into English to the best of your ability? I do. Thank you. The appearances of the other parties, please.
Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Royal Village.
I'm Linda Brown Thornsberry on Royal Village's part.
Mr. Roberts, your name, please.
Dad, oh, Dad, Dad, oh, Dad,
Johnny Roberts.
Today is the day and time set for the termination of tenancy hearing. Mr. Roberts presented requesting, well, Mr. Roberts presented with his son to act as the translator, and the court said no. The court secured an ASL interpreter and is ready to proceed with the hearing this morning. The interpreter, Ms. Banaki, has indicated there's a difficulty in not being able to see your hands and ask for you to appear physically in court.
Is the picture gotten better? Because he can see.
No, you're freezing, which means she cannot see his hands.
after that.
This court is attempting to make accommodations to conduct this hearing. Ms. Banaki is available until 2 p.m. Mr. Roberts, is there anyone else who is available to bring Mr. Roberts, the named defendant, to the courthouse?
No. He said, my son, this is my son.
Your Honor, may I say something?
What, ma'am?
I know that Senior Roberts, he does drive by himself. He has a vehicle and his son has a vehicle. He drives every day.
But he couldn't get there if he wanted to. He doesn't know where it's at. And he doesn't read. He couldn't find that courthouse without me.
That's where I was about to ask. Mr. Roberts, I was going to ask, is there a reason why you cannot bring your father and stay in the car and let your father come in so that we may conduct this hearing? Otherwise, he is absenting himself and refusing to accept the accommodation from the court.
Look.
Mr. Roberts, the younger,
What?
your device keeps freezing. The interpreter cannot understand your father,
Yeah.
and I cannot understand. I am begging you to get him to the courthouse so that Ms. Benaki may assist him so that we may take testimony in this matter. We have now been going at this for over 15 minutes. You could have been here already. You are endangering your father's ability to participate in these proceedings.
I'll get dressed. We'll be there.
Your
We'll be
Honor,
there.
Hold on, Mr. Robinson,
I'm sorry, Judge, but I know Ms. Brown Thornsberry has a personal court matter that's scheduled for noon, and I have a meeting with Van Buren Township at the township, or actually at the police station at 1 o'clock with several participants. So I'm not trying to make things any more difficult, Judge. I just want the court to be aware of that.
so was Ms. Brown Thornsberry not prepared to give testimony that lasted past noon?
Our testimony will be pretty brief, Judge.
Judge, I had this case down for the 31st. I wasn't aware it was going to be today. I had it on the 31st, so I apologize for that.
Judge, the court will recall it was scheduled last week, and then Mr. Roberts had called in and said he couldn't make it for some reason, so I'm not quite.
Mr. Roberts last week contacted Sandy and indicated that Mr. Roberts, the named defendant, was unavailable, and the court adjourned it to today. If Mr. Robinson, if it was conveyed to you, was the 31st, that was an error, as this courtroom doesn't have a docket on the 31st.
Yeah.
I am not physically here on the 31st.
And I think, Judge, also originally we had requested it to be in person, but that the interpreters don't do in person. So that's why it was switched to Zoom, if I recall.
Ms. Benaki is here standing,
Oh, I
I think,
understand.
20 feet from me.
Yeah, I understand, Judge.
So here's the problem now. The court's ready, called the case on time. Ms. Benaki is here, ready to proceed. Plaintiff's witness is unable to stay past noon. Defendants won't bring themselves to the courthouse. Plaintiff's attorney is available for maybe 45 minutes to an hour. Who bears the penalty or the weight of not being able to proceed this morning?
I can go between both cases if I can, because they're both on Zoom. Just
Mr.
pardon me if I
Robinson,
have
you need to have
put you on
conversation
mute.
with your client because this, no.
I apologize, Judge.
No, you don't, because you keep doing it. And we're now reaching the point where Mr. Roberts is not going to come to court. The witness is not available. The attorney will not be available. What do you want to do, Mr. Roberts?
What do you want us to do? I don't know what's going on. What's everybody doing? I mean, he said he wants to get this matter over with. He said yes, he'd like to go to court.
Mr. Robinson,
Judge, is there any way we can carve out a half hour sometime in the, well, I realize the holidays coming up, but just carve out a half hour where we can come back to court in person with my apologies to the interpreter?
apologies are fine, but the interpreting rate is what it is. Ms. Benaki, do you need to check your calendar, or will somebody else come from?
I'm not available for the next week. I'm leaving on tomorrow for a week to see the redwoods in California. You might get another interpreter if you ask within the next week, but we have a limited number of legal interpreters. And that's the problem. So at least 2 weeks, a week to 2 weeks, or give multiple dates. I'm back on June 1st.
Here's the additional problem. I don't have a secretary, so I have to use other people to cover for in person. I'm looking at maybe June the 8th. Thank you.
Judge, would you mind if I just grab my calendar quick?
I was gonna say that, oh, jeez. That's fine. I need to. I need a CER on the 8th. I have. Of course, I have a docket on the 8th. Mr. Robinson, I'm looking at potentially Thursday, the 8th. It would have to be in the afternoon. I have a criminal docket in the morning. Mr. Roberts, are you available on June the 8th in the afternoon?
Yeah. Yes.
What's Michelle's number? Michelle, what's her number? Do you know? Hey, would you be available for a short hearing in the afternoon on Thursday, June the 8th? This would be a live with an interpreter. Yes. Like 1 o'clock. We're waiting for Steve Robinson to check his calendar. Thank you, ma'am. Okay, bye. Mr. Robinson?
Yes, Judge.
Yeah.
June 8th at 1 p.m.
That would be great, Judge.
Yeah. But
Mr. Roberts, are you available on Thursday, June the 8th at 1 p.m.? I don't even have it.
I thought that Robertson
Mr.
said he was, but
Mr. Roberts?
disconnected.
Mr. Roberts, can you hear me? Mr. Roberts has left. The court is adjourning this matter over to June the 8th at 1 p.m. live in courtroom number 1. And we'll request again that the Deaf Community Advocacy Network send Ms. Rose Benaki to serve as translator. Notice will be mailed to Mr. Roberts of that. He's gone, Ms. Benaki, so. I know. June 8th, 1 p.m. here in courtroom number 1. Anything else, Mr. Robinson?
No, Judge, thank you.
Thank you. Thank you, Ms. Benaki. That concludes this court's docket for the day. We stand adjourned. Usually interpreters always have to move the furniture, but this is nice. You just swivel.